You can go over to community corrections and they will remove that tether.
All right, great, thank you.
Thank you. You need to give them at least an hour or so. We have to get the order in, okay, Mr. Kelly Payne?
Okay,
Thank you.
thank you, Your Honor.
You're welcome. Roll call the State of Michigan versus Alicia Joy Williams, case number 21 F20296.
Ashley Lonnie for the people.
Ready in that matter, Your Honor. Lauren Brown, Deputy Chief Public Defender, appearing on behalf of Ms. Alicia Williams. Your Honor, I have spoken with Ms. Williams as of June 24th. She indicated that she was eager to go forward with this matter. I attempted to contact her today, was unable to reach her. I would respectfully request an adjournment of this matter, as something may have arisen to prevent her from joining us today.
Thank you very much, Mr. Brown. Ms. Lundy?
Request a bench warrant.
What is her history in this case? Has she had any non-appearances in the past?
Your Honor, starting in the beginning of the case, she was present on April the 29th, and then we adjourned to May the 20th. At that time, the May the 20th hearing was adjourned so that Ms. Gaines and Ms. Williams could connect and for the defendant to get information. And then she was present on the 6/3 date to adjourn for negotiations and discovery review. And then we set this date on the 24th. So she was present for all previous hearings, but it does seem like there was some difficulty with communications between her and her attorneys.
And are you able to proceed today?
Yes, Your Honor, Detective Lewandowski is here.
I understand. Thank you.
Your Honor, one thing with respect to the prosecution statements about difficulties between communication between the defense and the client, I don't think that she is in a position to be able to state that definitively, if that's going to be a consideration in bond.
It's not. I'm more concerned about the fact that they are able to proceed and your client is not present and that she has not had any contact with your office since the June 24th date. So that is what my main consideration is. I am also considering the fact that the policy these days with respect to non-appearances is to give a second opportunity and to schedule a show cause in these types of cases. So those are the two things that I'm considering and I'm weighing at this time. So.
Thank you.
Your Honor, I would not be opposed to going back to a PCC.
Okay. All right. I will schedule this matter for a probable cause conference. Okay. July 29th, 2021. And that will be at 9 a.m.
Thank you, Your Honor.
Thank you, Your Honor.
I am noting that the defendant did fail to appear.
Detective, you're all set if that's your only case.
Oh, Brian, I'm sorry. I need to check one more box on there. Thank you. All right. Are we down to preliminary examinations at this point? Okay. So do you believe he's coming into the, Mr. Brown, are you going to be coming into the courtroom on some matters that are in person?
Yes, I will, Your Honor.
Okay, all right, thank you. I was just trying to figure out how we're going to maneuver this because we can't hear on Zoom the people who are talking in the courtroom. So I'm just trying to figure it out. Thank you.
Okay.
Judge, I believe that Mr. Gaddy and I are ready on the Clifton matter.
All right. Thank you. The court will call the case of the state of Michigan versus Deontay Montez Clifton, case number 21 F20196.
Andrew Childers appearing on behalf of the people.
Mike Gaddy, Assistant Public Defender on behalf of Mr. Clifton. Mr. Clifton, are you on the feed?
Is there a Deontay Montez Clifton? If so, please unmute yourself and state your name. Is that you? That's him in the hearing.
That's him in the conference room there, Judge.
All
Could
right.
you unmute yourself, Mr. Clifton? Or ask a corrections officer to?
There you are, sir.
They trying
You're
to get me
unmuted.
on mute.
You're unmuted now, sir.
Oh, okay, they can hear me. All right.
Please state your name, sir.
Deontay Montez Clifton.
Good morning, Mr. Clifton. All right, today's the day and time scheduled for a police examination in this matter.
Your Honor, at this time, the people are unable to proceed.
Your Honor, I'm sorry, Mr. Clifton, with your permission, I'm going to ask the judge to dismiss this case.
Yes, that's good.
I move to dismiss, Judge.
Thank you, Mr. Clifton. I'm going to dismiss this case based on the fact that the prosecution is unable to proceed today. The dismissal is without prejudice, and what that means is if the prosecution is able to proceed at a later date, this matter could be reauthorized. Do you understand that, sir?
Yes, Your Honor.
All right, thank you. The matter is dismissed.
All right, thank you.
I'm sorry, I can't hear you. Okay. And so, how many more votes do you have? Mr. Brown, are you present in the Zoom environment? Mr. Lauren Brown? Is there someone who could update me on the status of the Jamel Witcher matter, please?
Morning, Judge Ray Richards on behalf of Mr. Richard. Mr. Danner and I have worked out somewhat of what we're asking for an adjournment. He's with another counsel with the defense attorney. We're ready to go once he's ready to.
All right.
Richard is here.
All right, thank you so very much. In custody. Okay. Okay, thank you. Is there anyone here who's present who could give me an update on the status of the Benavides matter?
Your Honor, Lauren Brown, Deputy Chief Public Defender. I've contacted Ms. Benavides a couple of times. I've spoken with her directly in July, and she was very much anxious to see this matter through. I contacted her this morning and left a message. I wasn't able to speak to an actual person.
All right, I'm gonna call the case then. Who's the prosecution on that one? Is that you, Ms. Tanner?
I think this is Mr. Danner's case.
Okay, he's in the meeting room on something else, so I'll just wait then.
All right.
And Ms. Tanner, I understand that you're the prosecutor with respect to the Aldrich matter and the Sinclair Marcel matter, is that correct? Yep, that's it, I'm sorry. That's, I don't know why I read that, that's his middle name. Yes, Stefan Scott, okay. And those are gonna be 2 examinations, is that
Yes,
correct?
Mr. Brown and I haven't had a chance to speak to kind of see if they're going to proceed with the exams or not, or we're
All right, thank you.
We're ready to proceed on examine both those matters, Your Honor. I believe they're both in person. I'll be in the courtroom shortly.
Okay, thank you so much. The court will call the case of the people of the state of Michigan versus Stephanie Doris Benavides, case number 20 FB 1536.
Lou Danner for the people.
Ready in this matter, Your Honor. Lauren Brown, Deputy Chief Public Defender, appearing on behalf of Ms. Benavides. Your Honor, today, date and time set for the preliminary examination. I spoke with Ms. Benavides in the past. She appeared ready and eager to have her day in court. I have no explanation for her absence. I would respectfully request a 2-week adjournment.
Your Honor, the people request a bench warrant in this matter. Is one, due to the nature of the offense, it is a high-class felony in this matter, Your Honor. We do have a prior failure to appear, looks like back in 2020, and then we didn't get her back again until, so it looks like she was bench warranted in July of last year, and then we didn't get her back until June for an arraignment on the bench warrant, and then we have this matter, and then we had a hearing. That's the time she appeared, and then at that point in time, we had this set for a prelim, and she's not here today. So this would be the second time in which she has failed to appear on a home invasion first. The victim is here. Our officer in charge is here, so we would request a bench warrant, Your Honor.
Thank you. So that I'm clear, are you indicating that she failed to appear in July of 2020, and we did not have her back present with us until June of 2021?
That is what my notes say, says, Your Honor, that, yeah, this case was called, it was a PCC on, looks like 7/9/20. The case was called at 110 with defendant failing to appear. And there was a request at that point for an adjournment. And then they passed the matter for a while so they can contact her again. That was unable to be done. So then it was recalled and the bench warrant was issued. And that was, the note appears that is from July of 2020.
Thank you. I do see in the court's file that there was a bench warrant that was issued for her on July 9th of 2020. The next court date was not until June of 2021, so my notes do reflect that as well. Any response, Mr. Brown?
No response, Your Honor. Thank you.
Thank you. Bench warrant to issue in this matter. She has failed to appear and has a history of failing to appear. In addition, this is a home invasion first degree matter, which has concerns for public safety. And the court will set a bond in this case in the amount of $10,000 cash or surety.
Thank you, Your Honor. Thank you for appearing, Ms. Hines and Deputy Betts. You both can sign off.
Thank you.
Thank you. All right, it appears that we have 3 preliminary examinations today. They're going to be called in this particular order. I will be calling the Stefan Scott case first to hold the examination, and then the Britton Aldrich, and then the Douglas Hill. In the interim time period, the court will be in a 5-minute recess.
Thank you, Your Honor.
Ms. Reiser and Mr. Gaddy, we have, we're working on a matter that's going to require some additional input here in the courtroom. So I thought maybe we would start the Zoom hearing.
Yep,
and see how much
absolutely.
We can how much we can get done with respect to that one, if you're ready.
Yes, we are ready, Your Honor.
All right. People of the State of Michigan versus Douglas Eugene Deshaun Hill, case number 21 FB 1594.
Good morning, Your Honor. Amy Reiser on behalf of the people.
My name is Rising. Mr. Gaddy, if you've placed your appearance on the record, we did not hear you as you are muted.
Honestly, I know how to use this. Your Honor, if may Ms. Reiser and yourself and I have a brief breakout on this matter.
Yes, you may. All right, the court will pass this matter, and we've had a breakout session with respect to the people of the state of Michigan versus Douglas Eugene Hill. And the court will pass this matter and give a breakout room to Mr. Gaddy and to Mr. Hill so that they can have an opportunity to speak
Oh,
and
that
get
would be,
to the preliminary examination that will be called at the end of the docket today.
thank you, Your Honor. That'd be great.
Mr. Hill, please hit the join button. I think he's already done that. All right, thank you. You ready to proceed? Yes, sir.
My client would not like to give up his right to be able to confront the witness. He is going to take that to the judge. The court is willing to do that. See if the witness will come and testify.
All right, thank you. Ms. Tanha? So the defendant is indicating that he would prefer to have his opportunity to confront the witness and have her presented here on, is August 3rd? A time that,
Yes.
that's the next time that this court is back out here. Right, and I'm not here. I'm here every other week, so that would be the earliest date I have. All right. August 3rd?
Can you address the issue of conflict?
You may.
Address this issue. Right now, it's conflict with that.
Can you bring the microphone a little bit closer because we're not picking you up? Yes, we can.
So on my client's phone, from the text have been taken away. It doesn't just affect whether or not he allegedly contacts the alleged victim in this matter. It also contacts whether or not he can speak to his family, whether or not he can even do store orders in the jail. With respect to the request that he still be allowed to contact his family, still be allowed to be able to do not have any problem with this inability to be able to have any contact with the alleged victim.
Mr. Brown, is there some way the jail is able to limit who he's calling that you are aware of?
I did not know. So the court
No, the court does not know that answer.
the impression that the court knew all.
Yes, and you would be mistaken about that impression. So that's my first question, and I don't know if there is maybe someone we can speak to. No, okay. I just looked back at the transport and they do not know the answer either. So, you know,
They can limit, Your Honor, this is Amy Reiser, the jail can restrict or block a number for that inmate to call, or even restrict their time, that someone just has to talk to the jail staff.
thank you.
Mhm.
Thank you, Ms. Reiser from the prosecutor's office who is.
So to put it on the record, she said
They can restrict they can block a number so they can't call a particular number, or they can limit the time that they have in which to make any phone calls.
well, you asked for that.
All right, thank you so much.
You're welcome.
Yes, you may, Ms. Tanha.
Oh, I'm sorry. I thought that was off the brief for Mr. Brown. In regards to being able to call other numbers, Your Honor, unfortunately, again, I'm not claiming that we have any evidence of that at this point, but it has been a frequent occurrence to have an inmate call friends and family members and having them do a three-way, contacting the victim that way. Given that Mr. Scott has gone as far as using another inmate's PIN number to deal with them, I do have concerns that may take place. And while we can kind of, after the fact, try to go in and listen to jail calls, we can't monitor it to that extent where we can make sure that that hasn't happened or will not happen.
Ms. Tanha, with respect to that particular part of it, are there any allegations that any family member has been utilized to date for that? All right, thank you. Mr. Brown, with respect to that portion of your bond argument, are there particular individuals that he's seeking to call in this 2-week time period that we could? Yes. And this is his mother. Is that the person that's in the courtroom today? Thank you. Is that, it's his mother? Is there anyone else? No, just your mom? Okay. I would grant him the ability to call his mother. I'm hopeful that maybe the jail, if they can block a phone number, maybe they can make it so that he can only call one particular phone number. And I don't know if that's a possibility or not, but we can inquire as to that. And I would allow that. and if any calls are made to the complaining witness in this case, then it would have to be through the mother. Is there anyone else who resides at, is it the mother's cell phone number or the mother's home number? I'm not asking for the number. I just want to know if it's her cell phone or a house number that he'd be contacting.
Actually, it's too many cell phone.
Okay.
Because sometimes she might not be home, so I might call her cell phone.
Okay. The mom has raised her hand. So I don't know if you want to talk to her first before she says anything, Mr. Brown.
It would be just the home. Her cell phone will not accept the phone, so just the phone.
Is there anyone else who lives in the home with her?
My father, my sister, my niece.
So the court is concerned about not being able to establish who at the house he's talking to. I would prefer if it was a cell phone number and it was directly her. Ma'am? Yes, you may. She wants to tell you something, Mr. Brown.
She's indicated that her daughter's cell phone would probably be the one to use. If they want to allow it.
Counsel, please approach. All right. So why is it the mom can't get the phone calls?
She says her phone calls, her cell phone won't go through her phone call. I didn't actually too many details because it probably would have confused me.
Okay.
So for whatever reason, her phone doesn't work, but her daughter's does. If there's no allegation, is that the daughter has been part of making any phone calls or any issues here. And certainly we could ask Ms. Tamara to check with the complaint witness.
I don't believe there's been any allegations. I can say that confidently about that.
Okay.
There hasn't been as far as we know. I still have concerns. I have more concerns that I'm closer to get to someone who there are ways around here we can find some things out, but I'm sinful, unfortunately, but it's from, with little experience. There's many ways that people have used code names, and if there's another
of concerns that it has with having anyone other than the mom being the person that can be contacted. And based on that, I'm going to order that the bond be modified to allow contact with the mom through her cell phone. If the mom can't work that out where she can receive the calls, then I don't know what else to say about that, but that is what I'm ruling, that he can make phone calls to the mom's cell phone. And she can call her carrier or whomever needs to be contacted to try to work that issue out.
With respect to
violation, our client has asked the court to consider allowing him to be tethered to his family's home. He would abide by all orders and restrictions of the tether. He would have no contact with the alleged victim at this time.
Thank you, Mr. Brown. Response from the people.
We're seeing how the defendant has made contact with the victim several times while strictly ordered not to do so from the jail. We have no confidence that he would abide by court orders at this point, especially in out of custody. In fact, our concerns would be that it would go above and beyond just calls and that he would make physical contact. We are concerned for not only the safety of the victim, but given the facts of this case, the safety of her children and possibly the public.
Thank you. Given that there is this particular matter and another matter that I believe is likely to be authorized or has been authorized in this case with similar allegations, as well as the fact that there are bond violation arguments being made with respect to this case, it appears to the court that the court is very concerned about the safety of this particular complaining witness in this case, and bond will remain as is, with the exception of being modified to allow cause to the mother, and I'm giving him the earliest possible date that I have in order to hear this particular matter. So we will see everyone on August 3rd, 2021 at 9 a.m. Ms. Tanha, I would request that if you have concerns about being able to move forward, you express those to Mr. Brown as soon as possible, as soon as you know that, so that we can be prepared to address those arguments early on in the process.
Of course, Your Honor, for the record, I just found out today, I was called back and I wanted to ask for some time with the court and speak to the witness to make sure we can proceed as soon as I do this.
Thank you.
I'll make sure to do that.
Thank you.
If I may just get out the retrieving document for the Aldrich case.
You may.
To call that one next.
Yes, I will.
There you go. I know. I didn't even know if we were still doing it.
court will call the case of the state of Michigan versus Britain Keith Aldrich, case number 21 FB 1667.
Good morning, Your Honor. Brianna, Assistant Prosecuting Attorney in Washington.
We're ready.
Good morning, Mr. Aldrich. All right, Ms. Tanha, you may call your first witness.
Thank you. People call Jennifer Davy, please.
Raise your right hand. In your testimony to the court, you swear or affirm to tell the truth, the whole truth, nothing but the truth? Please be seated. You'll have to speak.
Good morning, Ms. Davy.
Good morning, Judge.
How are you?
My heart's beating.
All right, just take your time, take a breath, and breathe in and out, and we can do this. All right, so a couple of things, when they ask you questions, you have to answer yes or no. The recorder does not pick up or it doesn't distinguish between which one if someone needs a transcript, okay? Everything's being recorded, and so we need you to speak into that microphone loud and clearly so that everyone can hear you and that her recording system over here can pick that up, okay?
Yeah.
All right, thank you.
I'm in court.
All right, you may proceed, Ms. Tanha.
Thank you. Good afternoon, Ms. Davy. I think we're almost at the afternoon. Ms. Davy, I'm going to ask you some questions about an incident that took place in June of 2021. Before we get into what happened, can you please tell me if you know someone by the name of Britain Aldrich?
Yes.
Okay, and who is that person to you?
He was my on and off boyfriend for 7 months.
And in June of 2021, were you still dating or had you broken up? If you remember.
That was, I'm sorry, that was after the incident, correct? That was June 16th.
We're going to talk about the incident on June 16th.
Okay, so that's when he first after the fact,
You were not dating.
No.
And on June 16th of 2021, where did you live?
At my condo.
And
Was she
that
sworn?
8570.
Was she sworn in?
Yes.
And as far as you know, is that Ypsilanti Township, state of Michigan, and Washington County?
Yes.
Does anyone else live there with you?
My daughter was half-time.
And how old is your daughter?
4.5.
And was she there on June 16th?
No.
Could you tell the court a little bit about that residence? What it looks like? Do you rent? Do you own?
I own. It is a nice, it's nice to me, 2-bedroom condo, 1.5 bath, nice little fenced-in yard.
And if you could tell us a little bit, just to help get a visual on kind of the layout. So you walk into the front door, what do you immediately see, and then house?
It's an open concept, so you have the living room and you can actually see the dining room kitchen from there, and then you can see upstairs, the stairwell for upstairs. It's really all you can see when you walk in.
So we're going to start talking about June 16th of this year, 2021. Did something happen involving Mr. Aldrich that led to police coming to your residence?
Yes.
And the incident that took place, was it during the day, an evening, nighttime?
It started in the evening throughout the early morning.
And if you could tell the court the circumstances during which Mr. Aldrich first arrived to your residence. What happened when you first got there?
I don't understand.
Oh, sure, I'll rephrase. So that day, was Mr. Aldrich at your residence?
Yes, ma'am.
Okay, and what happened when he got there? Was it kind of pre-planned, or did he show up? What happened that led to him being there?
As far as I remember, he was already there when he made plans to go out that evening.
And you and Mr. Aldridge, were you having any kind, was it a calm, good time at some point during the day, or?
Yes, I know I was excited to actually get out, and he was too. We were looking forward to it, yes.
And did that change at some point during that day or evening?
Not until the place we got to, and things kind of went sour from there.
Could you tell the board a little bit about that, what happened? And where you were, first of all?
We went to Taco Tequila Turntable Tuesdays in Detroit.
I like to say it, yeah.
So it's a mouthful. So that's where we went, and we were having a good time. We were getting drinks, and I met a few people, and danced on the little bitty dance floor with them, and we both met a couple and talked with them, and then one of the men that was a part of the couple that we met, we were trying to, oh goodness, was trying to get, I thought, weed from him, and it turned out to be, he said that.
Objection is yours.
I'm sorry, when you say he, who are you talking about?
The couple we met, it was a man, a wife and a woman.
Oh, okay. So just to explain the objection, so if it's about anything that anyone other than Mr. Aldridge said, then we can't hear that at this point.
So there was some information given, and he got highly upset about it, and he stormed out, where he kicked the door, and the security guard was like, oh, something's wrong with him. And he's walking down the road, and I'm following behind him because he's really ticked off.
Okay.
And
I'll pause you there, sorry, before we go on. When you say he stormed out and he don't know if that's who you're referring to.
Britt.
Oh, okay, I'm sorry, go ahead. I just want to make sure we know who we're talking about.
So that's when it all started.
Okay, so at that point, you were following Mr. Aldridge?
Yes, out to my car.
Okay. And did anything happen from there on out?
We had an argument, and then proceeded in the car to drive home. And I'm driving on 94, and continuously I was having to pull over on the side of the road because he kept putting my car in neutral and whatnot while I was driving down the road. Yes, and during that point also is when he took his feet and pushed him up against or slammed him up against the windshield and broke the windshield.
And you mentioned the car. What kind of car was it?
It's a 2019 Jeep Cherokee.
And are you the owner of that car?
I am the sole name on the title.
And you said he was kicking the windshield, so it was sticking in front.
Yeah, he took his legs and kept slamming on the windshield until it started cracking and all that.
And was he doing that while you were still driving?
Yes, ma'am.
And what did you do with it?
I was focusing on not trying to get in a wreck.
And so you kept driving, and where were you heading?
Home.
And so after he broke the windshield, did anything happen after that, as you're driving?
I'm screaming at him, he's screaming at me, and then we finally make it to the condo. I remember he was like, we need to talk, we need to talk. And I was like, I need a minute. I just need to go park down the road. I need to sit, I need to smoke a cigarette. I need to calm down. And so he got out and he was talking, and I started to drive away, and he threw a Gatorade or water bottle at my head. It came through the window and hit me on the side of the head, and I just kept on driving. And then I did go to the end of the complex and park on the other side.
At some point, did you come back home to
Yes.
Toronto?
Yes.
And was Mr. Aldridge still there?
Yes.
Did anything happen at that point?
I had come back and he was there, and I was going into the condo, and I shut the door, and then he came through, pushed that open, and we went upstairs. He followed me, and he was manhandling me. I guess that's the best way to put it.
Can you, as much as you can describe, could you describe in what way, what part of his body was he using, what part of your body was he touching, if any?
And I'm going to object to this testimony. This is part of the mystery, I believe, which isn't something that this court needs to take testimony to. What we're here for is the life of the person. Most of this stuff is somewhat irrelevant to what the charge is. The charge of the court is trying to do some felony largely from a person. These others are charged as misdemeanors. The court does not need to hear testimony on those. It's not going to need to have it. Right now, this is more prejudicial than COVID of largely from a person.
Response.
Your Honor, while it's not necessary, it is certainly relevant and corroborates the whole pattern of events. Furthermore, I am not aware of any legal authority that would prevent us from using testimony that was part of the pattern of what happened that night.
Is there?
We're not trying to cooperate with the whole pattern of events. They're here to show evidence that was largely from a person that took place. The objection here is this is more prejudicial than COVID. It doesn't go to the purpose for which we are here, which is largely from a person. All it really is, it's basically just prejudicial information, and it's not necessary for the very purpose of that here, because the largely from a person.
Your Honor, as Mr. Brown, I'm sure is aware, just because something is prejudicial doesn't mean we can't give testimony about it. The rule says it has to be substantially more prejudicial. Again, this is testimony that's been taken about what the defendant did. I don't see, yes, it is going to be somewhat prejudicial because he's testifying as to the assault that took place. And it sounds like we're getting to the largely from a person from there on out. But again, it's substantially more prejudicial than probative, and I'm not aware of any legal authority that would prevent us from taking the testimony.
All right, the objection is overruled. I believe that the evidence that is being presented is a part of what occurred that night. I do not believe that it is more prejudice than probative, and I think that's the standard, so I will allow the testimony.
Thank you. You said that he manhandled you, and my question was if you can describe to the court what parts of his body he used, if any, and what parts of your body were touched, if any.
Just as he's very tall and I'm short, so it was my arms and stuff and part of his chest doing that, because I was wanting to leave out of the room, and where it was positioned, I was kind of blocked in. And then at that point, that is when he hit me, and I went in the corner and I grabbed my lamp and I started swinging it, and I'm like, just leave me alone, just leave me alone, I want to leave. I tried to jump over the bed, and he's like, you're not fucking going anywhere. And then he left, and at that point, I'm getting my dogs on the leash, and I'm throwing some stuff in a bag to leave.
And so you're able to, at some point, get your things together to leave. Were you able to leave?
He had been gone for a little bit, and when I left, I got in the car, put my dogs in the car. I started to back away. I kind of noticed something was wrong with my car. It didn't feel right, but he was coming out and I was like, I'm going, I don't care. So I start driving and the thing started saying that my tires were being inflated tremendously and I'm like, I can't stop. So I just went to the little corner store maybe half a mile from my condo. And that's when I got out and saw that 3 of my tires had been slashed.
And from your testimony, you were of course driving earlier that day. Have you noticed any problems?
No, just the windshield. Yeah.
So once you noticed that your tires were slashed, what happened?
I opened the trunk and was talking to my dogs and telling them it's gonna be okay. And then I just sat there, I didn't know what to do. It was and then I called my best friend Mary. And I had the dogs and it was in the wee early morning and I'm walking in the dark with my dogs on the side of the road back to the condo while I was on the phone with Mary.
Once you got back to the condo, was Mr. Aldrich there?
Yeah, I walked in and he was sitting in the chair eating a bowl of cereal.
And did he say anything to you?
There was something said, I really don't remember. And then he threw the bowl and it shattered.
He threw the bowl of cereal?
I believe it's when he was saying he wanted his phone, he wanted my phone so he could call his mama, I believe, if I can remember correctly. Yeah.
And did you, the initial request, you requested your phone, did you get it?
No, ma'am, I did not, because the last time he got in one of his things,
Objection to those about the last time.
We'll leave that alone for now, Your Honor. We can move on. We're not gonna cover that part right now. We may revisit it if need be.
Thank you.
So initially you did not give him the phone. Did he request the phone again?
Yes, multiple times, even when I was on the phone with my friend Mary, she was on the phone with me quite a lot when all this was happening. And then I don't remember how, but I took my phone and I went away from the condo into the yard area so I could talk to Mary without him being present. And I know I was running away and then he was running to me and we ended up catching up where I went on the fence and he was trying to get my phone from me. And he did, and then that's when Mary's like, Jen, I'm calling the cops. And then he ran off with my phone and left.
Could you tell the court a little bit about how he got your phone from you, if you remember?
That's when I was running away right outside the gate of my condo down to the grassy area, and he was running to me, and then I go back around and he's running to me and we go like this, and then he gets up against he gets right up against my back, pushing me up against the fence, and then he's trying to get my phone. I'm trying to hide it because I'm right here with the fence, and that's how I got it.
So you're making some movements that aren't going to be captured by recording. So
I'm sorry.
No, that's fine. I'm just gonna I'm explaining to you why I'm gonna just talk through them so that we have a recording of it as well. So, and tell me if I'm not accurate in while I'm explaining what you did. I saw you do. So essentially, it looked like you were kind of putting your hands up as if you were pushed against a wall of some sort. Is that accurate?
To start with, yes,
Okay.
and then brought my hand down with my phone to try to hide it.
Okay, and when you're doing the motions right now, hiding it kind of by your chest or stomach area, with your other hand over the hand that's holding the phone. Is that accurate?
Like this, yes.
And you testified that he was behind you?
Yes.
Okay. And what was he doing with kind of his hands or with his body?
Well, reaching over me and going in front of me and grabbing my phone and jerking it.
Thank you. And he was able to get your phone?
Yes.
What did you do once you had?
What did I do? I was like, holy crap, that's everything. That's my whole life right there. And I went and sat on my front porch and just sat there.
When you say that's my whole life there, could you explain what you mean?
Response?
Your Honor, she, there wasn't a objection to her testifying to what was going through her head and now. Well, she's describing how she felt after the Washington person. So, well, she answered my question of what was going through her head or what she did, and I answered it, and then I asked the clarification. So there's no objection to the answer itself. I'm not sure how there's an objection to the clarification of what she meant.
So the response was, that's my whole life right there, is what she responded to in terms of how she was feeling or what was going through her head at the time. And now the question is to explain what she means by, that's my whole life right there. Is that correct? And your objection is that that is not relevant to what she meant by that term.
Now, there's no point, no material relevant point to asking how she felt.
Well, Your Honor, there is part of the case law for any law, and I don't have it ready, but I can find it if it's necessary, is that you prove that the victim was somehow deprived of the use of the item. So by asking to clarify, that will speak to that. Again, I don't know if you don't have an answer to that.
Can you ask that? I'm gonna roll. Can you clarify the question to go to that point, Ms. Tanner?
So she answered something to the effect that that was my whole life. My question, I don't want to leave her into this, but my question is to clarify that what I'm anticipating her testifying to is that there's a lot of information on the phone, but also.
I understand. I'm asking you if you can just ask her that question.
Oh.
Okay.
Okay, so Ms. Davey, what did you mean when you said that's my whole life?
No, that's not what I mean. What I mean is, can you ask her, was she deprived?
Oh, yes. I found this a long day. Ms. Davey, were you deprived of anything by not having a phone in that home? Yes. Could you tell the full of it?
Communicating with my only best friend.
The issue is just allegedly phone. If she said that the phone was taken, we don't need to know. It's her phone. She didn't allegedly. We don't need to know what was in the phone, but the phone. All we know is what she did, and she had a phone in the state. And all this other stuff is irrelevant to the material. The only point. I don't think it is. But what she said was all this really has no material.
Ms. Tanner.
Your Honor, the court order ruled again will speak to whether she was deprived of some benefit of that.
And I will allow it for that purpose.
In what way they were deprived in that moment? by Mr. Aldridge taking the phone?
Well, the main first thing was talking with Mary through the majority of what had happened. She is my security. And
Ma'am,
the other thing,
can you move closer to the microphone or the microphone closer to you, please?
and then secondly, I didn't have my daughter, so we got to have my daughter. So my phone is pretty close to me on those weeks, and I do check it randomly. And then, you know, just those are the two main basic reasons that I let go with. Yeah.
Do you know, and if you don't know, do you know how Mr. Aldridge, or I should ask first, did Mr. Aldridge come point leave that area?
Yes.
And how did he do so?
And my other car that I had given him permission to use.
Maybe I'm going to present a few different items that you and ask you some questions about them. Your Honor, I may approach before I do so, if I may, I'm going to show people's proposed exhibit.
Yes, you may approach.
And I'll show you to Mr. Brown before I do. They have been now shared as part of discovery. Okay, actually, we'll just do it all at once. So 13 proposed exhibits.
Thank you. You may.
This baby, I handed you public exhibits 1 through 13. I'm going to go through them one by one to get into some questions. We'll start with the proposed exhibit number 1. Please tell the court to recognize what that is.
Yes.
And just tell the court what that is.
It is the door jam of my door.
And is that the door that Mr. Aldridge came through?
Yes.
Was there any damage to a previous Aldridge?
Yes.
There was something previous.
Yes.
Did that damage look the way it does in the video?
No, that I can actually, the previous one, you can actually lock the door. After this, there's no way to lock it.
And is that a fair and accurate depiction of the way the door looked on June 16th after it was altered?
Yes.
And further, I believe you did testify to this, but was the door open or closed? I'm sorry, before Mr. Aldridge came through it, was the door open? So just proposed exhibit number 2, if you could tell the board to recognize what that is.
It's the same thing as the door jam.
And again, is that a fair and accurate depiction of the way that door looked after Mr. Aldridge came through on June 16th?
Yes.
Remember, I would move to admit people to both exhibits 1 and 2.
Response, Mr. Brown.
Relative. The charge is
Your Honor, we're actually going to be moving, and we'll get there, we're going to be moving to amend the complaint. The damage done is actually over $1,000, so it will be very relevant for that.
Thank you.
I mean,
They may be admitted. Sorry.
Ms. Davey, could you please look at the proposal for the number 3? Yeah. Could you please tell the court to recognize what that is? It's not that one. And when you were testifying, you testified that it was where it was going to be, we need to know the public place. Is that where? It says the room that it was, this picture doesn't show. Oh, but that is the room. Yes. And is that a fair and accurate depiction of that after that night? And if you could look at what these are the numbers for, and the court not recognize that. Yes. And what? That's the other side of that bedroom with the occupation. And is that a fair and accurate depiction of the way that look after the incident was resolved? And at this point, I'm going to get into people for both exhibits 3 and 4.
Ms. Tanha.
Your Honor, we've already heard testimony.
I will not allow those particular pictures because they are not relevant to the actual charge of larceny from a person or malicious destruction of property, as I understand the 2 felonies to be at this time.
We'll move on. And I believe we then have people's both exhibit 5 and 6. I believe, if I'm following the right order, that those are pictures of humans, baby. Is that accurate? Yes. We're gonna go ahead and skip those and they relate to the domestic violence portion. We can move on to people who both exhibit number 7. Yes, ma'am, that's one of the times of the week. And that is at the chief that you specified for all the damage. Yes. And is that fair and accurate depiction of the way that the tires look on that after we do all these damage? And we could move to people for both exhibit number 8. You tell the court to recognize what that is. It's another tire of the Jeep. And again, that's very accurate depiction of the way that tire looked after all the damage that yes. And then people go close to exhibit number 9. You tell the court to recognize what that is. The last tire that was damaged. And is that a very accurate depiction of the way that tire looked? Yes. I would move to people.
Second objection. That's the this is construction.
Yes, but for the malicious destruction of personal property, I am intending on also amending that. That's also written.
Thank you. Then 7, 8, and 9 are admitted.
And this baby, people proposed exhibit number 10. That's just the back side of the Jeep. People
proposed number 11. That is, the child to take a picture of us.
And is that a very accurate depiction of the way your one should look after it's all the damage to them?
Yes.
And you're supposed to put the number 12.
It's the better angle picture of the one show that he was.
And is that a very accurate depiction of the way that one should look on June 16th after the television?
Yes.
And I was going to do it for 11 and 12 and what's the
Objection for the limited purposes of preliminary examination.
Admit it for purpose of preliminary examination.
And I'm going to stick to number 13. And Ms. Stevie, did you get some estimates for the damage done to the door as well as the vehicle?
Yes, I did. I went through progressive information.
And did you today present the prosecutor's office with two estimates?
I don't know if it was sent by them to the prosecutor's office, but they sent them to me and I forwarded them on.
Okay, to us.
Yes.
Your Honor, for the record, we do people's proposed exhibits 14 and 15. I did share those with Mr. Brown. As soon as I got them, I gave him a copy.
Okay.
If I may approach with those.
Any objection, Mr. Brown? You may.
I've marked those on the back because there's a lot of writing on them. We can tell if people supposed to do the number 14. Give the tell the court direction for that.
Yes, it was on the damage done to the Jeep.
And if you could please tell the court, and just to be clear, it is the Jeep we're talking about, that was damage as well.
Yes.
And if you could tell the court what the estimated cost of repairs are for the damage.
The cost total was $1,182.44. And then I had to pay out of that $500.
And if you could look closer to the number 15, tell it back. And to tell the court directly what that is.
This is fourth conduct.
And to tell the court what the estimated cost of repairs for the damage done to
the actual value was $3,343, and I had to do $1,000
Deductible.
deductible. Yeah.
Your Honor, at this point, I would need to make a proposal for the 14.
Mr. Brown? All right, with respect to 15?
Estimate for the condo and it's based on the damage that we saw.
Yes.
There's a picture. And that before you.
Yes.
What exhibit?
Should be 1 and 2, I believe. Is that a yes?
Yes. Sorry. Yes. Yes.
That damage was not, some of the damage was big.
There was a small amount of big district damage, correct?
You had kicked the door in previous.
A month before, yes,
Your daughter had locked you up.
that is correct.
Objection, and I'm sure I'm like to details of you.
All right, Response, Mr. Brown.
For the, I think that the established pattern previous details are important to show the time incident that goes about the clinic, that goes about all the others. I don't see why they would not be relevant here, because you would establish a foundation for the why she knows that the damage.
I'm going to allow the answer as to why she kicked the door in or what happened to the door, but that's the extent of the testimony regarding that particular issue.
So your daughter had launched it.
A couple of minutes prior, my 4-year-old daughter did walk us both out, actually.
So you kicked the door.
Kicked, no, sir. Budged with my elbow to open the door. Yes, and the jam was still in place.
And you caused some damage.
Minimally, yes.
So when we look at these estimates from the repair, some of it includes some damage that you caused.
Is that a question? It's on.
Yes, some of the estimate for repair includes the damage that you caused. Is that right?
I would say no.
No? Well, did you have the damage repaired?
The damage is
Let me make sure. Did you have the damage that you did here before you got
not at the moment, but the
this? So the
person.
damage is still there. You got this.
She was still answering the question.
The person that initially fixed the door now is the one who saw the previous damage from my daughter.
All right.
I'm going to strictly-
I will strike it. I will strike it.
So the damage that you caused and not been repaired before you.
Yes, that was at the bottom of the door.
So is that yes or no? Have the damage that you caused been repaired?
No.
So this estimate includes the damage that you caused, doesn't it?
Yes.
Now, is there some breakdown between the damage that you caused and the damage that you said my client caused? In this estimate?
No.
So looking at this estimate, you can tell me what is due to you and what is due to my client.
Not at this point, but it can be done.
So when we look at this, this is just really, also includes what you did, all right?
Yes.
So we don't really have the particular value of the damage that he did as opposed to the value of the damage that you did.
Not at this time, but
Now, when you testified, you talked about the events.
Are you still testifying about the estimate at this time?
No.
All right, I think we're still in the middle of her direct.
Oh, you're right. I'm sorry. I didn't take- that's okay. I didn't have a question with respect to the damage. I object to the damage that is listed here because it has to be it is not taken out. So for if it's going to be used for the purpose of raising the charge, I would object to that. So let me sum up and say that I don't object actually to this company. I do object to the use for the purposes of the client.
Thank you. And I'm going to allow Ms. Tanha an opportunity to respond to both the voir dire questions as well as the objection.
Your Honor, as far as both your questions, obviously the report in the document is a separate issue from adding the complaint. So if I may, I'll review my response in that regard.
Thank you. So you want my ruling now as to admission?
Yes.
All right, there a minute.
Do you see Mr. Aldrin Woodland? Yes. Please, either let us know what you see, something is wearing. Your Honor, having Mr. Aldrin is the only person in the form wearing an orange suit, I would ask the record to reflect that the witness is
Any objection, Mr. Brown? You shall so identify him. All right, thank you. You're a witness now, Mr. Brown.
So, today we testified about the events that so you described going to Detroit. Tacos and bags and drinks.
It was taco, tequila, turntable, Tuesday.
And you guys. At some point, Mr. Aldridge.
Yeah.
Stormed out of the place where you guys were. And you followed. And this is all still in Detroit.
Yeah.
Okay. And eventually you get into your vehicle.
Yes.
And you guys still out of the way.
Yes. Yes.
And so you're driving from Detroit back to your house. Right. And you said that while you're still driving, you said that it causes the damage to the windshield.
Yes.
Had you reached home yet before you caused the damage?
I can't hear you say that.
Had you reached home yet before you caused the damage?
No, it was on the way home on 94 right before the big tire.
So you're still in Wayne County.
I don't,
You know where the big tire is located.
and it's on the road. It's
This happened before you got.
from my recollection of that crazy thing on the road.
Response, Ms. Tanha.
We're not being familiar with it. I literally just Googling it. We're talking about a big tire.
I will take judicial notice that the big tire is in Wayne County, in fact. Having driven past it numerous times, so I'm familiar with it, just so you know.
So you testified that you were on the phone at some point. Did you talk to Mary before or after you got? When did you first pick up?
It was at night. We got back at night, so let's say 9, 10.
So had you last one, you got out of the vehicle before you do that? Talk to me.
No, I called and left her a voicemail when I dropped him off. I needed a minute.
Yeah. Before you drove off correct. Or across from the county. Taking.
Yes,
How long were you watching?
I didn't. I left a voicemail.
And so you came back
Yes,
and Mr. Aldridge was in the airplane.
no, that was later on. That was.
So, let's see. First time we dropped it off, and then we went and we cooled off. That's when it was.
I went to cool off, and at that time of cooling off, I called Mary and left a voicemail.
Then you came back to the condo, right?
Correct.
And Mr. Aldridge was standing inside,
Outside.
outside. So that you went to the condo,
Yes, I proceeded in
followed you.
after I shut the door and he probably they're coming through. Yes.
Now, did you leave out of the condo again after that?
After the incident, and he had left, and I was getting my dogs. That's the second time.
So. So when you went back out, did you go directly to the car?
Yes.
Was he still in the condo when you went back out?
No.
Really?
He was out in the parking lot,
Well, did you see what he was doing?
coming the opposite direction from my car and telling me you're not going anywhere.
So you just saw him walking towards
Yes.
you. Was he running at any point or
That wasn't until
this one?
at this point, no, just walking.
And so on the people's exhibit number 14. Is there a particular cost for the tire?
14. Okay. Yes.
What's the cost for the tire?
Let's see, there's the glass, there's the tire, $612 plus $63
Not
plus
just for the tires, but we
$7.50.
can do details.
That is on time.
Take that.
This estimate that you just called for, this number 14 has both.
So,
So they're
did you understand my question?
I guess I didn't, I'm sorry.
My question is for the tires. Just the tires.
Yes, sir. I thought I just told you. Here it is, tire. $612.63, $7.50, so that would be 67. 7, 4. Yeah. Can I have my phone? I'm sorry. I'm just not able to do the math right now.
Oh, well, I'm not, I'll just ask you this question. Is the price of the tires $700 now?
It's around that or just a little bit more.
But not.
Not for just the tires.
You are. You're gonna hold that question. I don't have any further questions.
Thank you. Any redirect? All right, thank you. May this witness be excused? All right. Thank you for testifying, Ms. Daly. Any further witnesses today? Yes, you may.
We do have someone in the courtroom who,
Thank you. All right, thank you very much. Is there a motion?
Your Honor, yes, I'm sorry. Your Honor, people will get a motion for binding over on the original one larceny from the person, but also malicious destruction of a building over 1,000, which would be under MCL 750-38038, as well as malicious destruction of personal property over $1,000 under 750-377A1B1. Those are both 5-year felonies and with $1,000 fines, or 3 times the value of the damage. I'm sorry, and we'd ask that the misdemeanor fall.
All right, so that I understand, are you adding account 5 and 6? Is that your motion?
Yes, Your Honor.
All right. And count 5 is as to the building, correct?
That's correct, Your Honor. So there was the one for the building, yes, count 5 for malicious destruction of building, and count 6, malicious destruction of personal property. Yes.
Okay. And the MDLP as to count 6 is for the Jeep.
Correct, Your Honor.
Thank you. All right, Mr. Brown.
With respect to count 1, we would say that that is an issue for the trier of fact. Count 2 is misdemeanor, which would go over the felony for fact finds of the person. As, the prosecution is not addressing counts 3 and 4, instead of adding count 5. So let's start with count 5. Count 5 goes to the, that's the malicious destruction of personal property. Or is that the building?
That's the, count 5 is the malicious destruction of the building.
Okay. All right, so the court has received the evidence.
I don't have any of the exhibits, by the way.
Make insurance estimate the damage to condo or the prosecution is attempting to raise the charge from missing to a felony based on the value of damage. The problem here is, as the testimony has come up, under this already taken care of. Condo here. This would be a locked condominium door. That now she's minimizing between she just bump it with the shoulder or whatever. But she admitted earlier on, about the cross examination was going, but there was damage. He was the gun. She had not go up to it, go on board, and then she could go over. She did it because it was already previously existing. The problem in trying to based on the cost is that so we cannot know because I asked him, was that damage, was the estimate from here, parsed out between the damage she had done and the damage that my client had. She could not say that. Because we do not know how much damage she caused to the building, we cannot know what the cost is for repairs that she caused, or the cost for repairs that he allegedly caused. Because the prosecution has not provided us with that information, we cannot allow, or the court should not allow the racist charge based on the cost of repairs. Damage related to felony has to be more than $1,000. We don't know if the damage she did was more than $1,000, or even up to $1,000, because we cannot touch that from what they simply have not given the court enough information to be able to make that determination. That's the duty. The court should know, or even probably, that the damage you did was damage over $1,000, as opposed to damage she did. They both added here together, and unless the prosecution has presented to the court specific information saying he caused X amount of damage, then it should not be able to use the damage that she caused to bump up the charge. That's that would be it's not doing that. So let's talk about the vicious destruction. That's one of the things that the two things are looking at are the damage to the tile, which comes up to about $70,000 or so, and the damage to the windshield, which is past $1,000 threshold. They're two separate. One occurred, was completed, and then another. The first incident occurred out of the company, out of this portion. That says continue, and so really got two separate as they're trying to lump them and make it into one incident. The fact is, the damage that she did, she clearly says that's in the way. If they want to charge, which is a charge discount, they have to charge in relation to something that occurred. Her allegations on the hours and concept. I submit that this is not an ongoing, continuing thing, because it's out of the vehicle, go and have arguments with. So the first one is really done. Those damages should not count. She can certainly do whatever she needs to do separately, to bring those charges that needs to be charged for damage. But it's clear that it's clear it's not ongoing. It's clear that kicking happened occurred stopped. They had some other things going on. He was out of the vehicle, they were in the house, a whole bunch of things separate from that. So I would submit that they have not, in either case, shown the court sufficient information to be able to raise the charge, because in fact, we've been doing these charges and different things together to make the amounts higher. And I don't think that's appropriate in this case. So I would ask that the court not find it to the 5 and 6.
Thank you. Any additional response?
A couple of things in regards to first, I think that
I'm sorry, can you repeat what you just said?
Yes, sure. Initially, what they meant that general, the venue is not an essential element of venue is not an essential element of criminal offense, and it will be hard to 285 more importantly, in this situation, and we argued that that's a question of fact to move forward, but more importantly, under 762.8, it states whenever a felony consists or is an culmination of 2 or more acts done in the perpetration of that felony, the felony may be prosecuted in any county where any of those acts are committed, or in any county that the defendant intended the felony or acts done in preparation of the felony to have an effect. The victim in this case is a resident of Washington County. She has ownership over that vehicle. When we heard testimony to, while the defense counsel argued that it's 2 separate incidents, it's one continuous pattern of damage to her property. Certainly, I think we've heard enough in testimony to argue that the intended effect would have and did continue into Washington County, where the victim is a resident, but also have ownership over that vehicle.
All right. I have a question about that. First of all, can you send the case law to both of us so I can review that? Thank you. And as to the argument as to the door.
Your Honor, as we did at the bench, we could have taken testimony from who the contractor for a living, from my understanding, if it's parsed that out, we could present more evidence. We would need some time to do so for a full breakdown of the difference. With that, I'll leave it.
Thank you. With respect to this matter, as to count 1, the court finds that the people have presented testimony from a witness that is credible, that shows that there was a larceny from a person by a probable cause standard, and the court will bind over as to that. Count 2, domestic violence, is a misdemeanor that will follow along with that particular felony. As to count 4, the malicious destruction of the, and I'll address why I'm making this ruling here shortly. Actually, I'm going to hold off on count 4. As to count 5, until I receive the case law, I do need to review that. As to count 5, the malicious destruction of a building, the testimony in this case was that the total cost for replacement was $3,343 based on, I should say repair value, based on an estimate from Progressive Home Insurance. In the court's review of the People's Exhibit, exhibit number 15. The court has reviewed this and does take into consideration the defendant's argument. However, it appears if just a brief perusal of this presents that in order to paint the part of the wall that was damaged, one coat at $690.95. To reset the dashboard, which was torn off, which is to detach it and reset it, is $345.54, which totals over $1,000 alone. If in a review of exhibits number 1 and 2, and taking into consideration the testimony from Ms. Davy, who indicates that she did in fact have to nudge, or however the door became open after the door closes, she did have to break into the place, that it was minimal damage and that the door jamb was still in place. The testimony clearly, if taken in that light, and in viewing the actual picture, shows that the entire door jamb on the inside of the home is completely detached. The wall is damaged and the floorboards will have to be removed in order to repair the damage. That alone is over $1,000. So therefore, I find that he is also being bound over on count 5, which is the malicious destruction of the building. Therefore, count 3 will not be bound over. I'm waiting to receive the. You're correct. Count 4 will not be bound over. And then we will, the court wants to review the case law as to count 3 and count 6 before I make a decision as to that. So give me one moment. Has it been sent yet? Okay, thank you. Thank you very much. Did you receive it yet, Ms. Heather? So, Ms. Taheim, in receipt of a one-page, it appears to be basically just the concurrence with some additional insight from Justice Marilyn Kelly. It's a preliminary examination, so I'm afraid that once I start it, I won't have an opportunity to get back to you very, very quickly, and therefore, and I do see that all parties are still present in the courtroom, and I don't want to inconvenience anyone to that degree. However, I will if you need me to. Thank you. I will pass this matter and begin the preliminary examination. When you have a copy of it, if you could pass it on to my staff, and then I will recall the matter as soon as I can. No one needs to go anywhere. The next examination is on Zoom, so if you want to stay in your spaces, you're free to do that. Court will call the case of the people of the state of Michigan versus Douglas Eugene Deshaun Hill, case number 21 FB 1594.
Good afternoon, Your Honor. Amy Reiser on behalf of the people.
Good afternoon, Ms. Reiser.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Hill. Mr. Hill is also here. Mr. Hill, if you could unmute and state your name.
I'm Douglas Hill.
Hello, Mr. Hill.
Hello.
All right, today is the day and time scheduled for preliminary examination in this matter.
That is correct, Your Honor. Your Honor, I do appreciate the court giving us the breakout before, after having spoken to Mr. Hill and reviewed the police report that I was given earlier today on a ancillary situation, kind of. I renew my request to adjourn this matter. I'm not going to go into all the stuff we went into in the breakout room, but this is a file that I think deserves some time to put how these things go together.
Response, Ms. Reiser.
Sure, Your Honor. As I indicated to the court at the bench, the people are objecting to an adjournment. The case has been adjourned from May 27th and again from June 17th until today's date, July 20th. I do believe the public defender has had ample time to prepare for the exam, meet with the defendant. And I believe in light of the threatening messages that the victim has been receiving, I believe that the request is coming because the defendant thought that the victim would not appear for the preliminary exam based on the threats that she's been receiving from him. So we're here and we've been ready to proceed since 9 o'clock.
All right, Mr. Gaddy, as I indicated during the breakout session that we had about an hour and a half or so ago, I am of the opinion that this matter has been going on since May, and agree with the prosecution that there has been ample time to get prepared. I do understand that there are issues that came up within the public defender's office, and that is why I did not proceed at that time with the actual examination and pass this matter, so you would have an opportunity to speak with your client with respect to this particular case. It is an hour and a half later, and I've held another examination in the interim time period. At this point in time, I am not willing to adjourn this matter any further.
Thank you, Your Honor. Also, for the record, I believe there was an offer in this matter to reduce the charge to assault with intent to commit criminal sexual conduct. Is that correct, Ms. Reiser?
Correct. The offer was plea to an added count 2 of assault with intent to commit sexual penetration with a sentence agreement of 1 year in jail, probation, and the sex offender registration.
I have gone over that with that offer with Mr. Hill, and he is rejecting that and choosing to go to exam this afternoon, understanding that once rejected, an offer is off the table and doesn't have to come back.
Correct. And I also, at the conclusion of the exam, would like to address the issue of bond.
Thank you. Mr. Hill, you understand that an offer has been made to you today, and that if you are rejecting that offer and you proceed to preliminary examination, it is Ms. Reiser's position that you will no longer be receiving that offer in the future. Do you understand that, sir?
Yes, I do.
All right. And she also indicates that she wishes to address bond. There have been some issues raised with respect to allegations that you or someone related to you has made threats to Ms. Nelson. You understand that, sir?
Yes, I am aware of those allegations.
All right, thank you. All right, you may call your first witness, Ms. Reiser.
Thank you. The people would call Shakira Nelson.
All right, Ms. Nelson, how are you today?
I'm good. How are you?
I'm pretty good. Please raise your right hand to be sworn. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right, thank you. Ms. Reiser.
Your Honor, I'm sorry, Your Honor. I'm looking at the Zoom screen. I'm assuming that that Ms. Nelson will be the only witness. If not, I'd ask to sequester any who may be waiting somewhere else.
The only other witness I would have is the officer in charge, Deputy Turpin, and she was logged on, but she had a meeting, so I don't see her logged on.
Okay,
And
thank you.
She would be the officer in charge, so she would be sitting through the exam.
Thank you. And for the record, so that there's clarity on the record, the only individuals on this particular screen, there are 9, they all show names at least. There's Mr. Hill, myself, Ms. Reiser, Mr. Gaddy, Ms. Nelson, who is the witness, the recorder for the court, as well as a victim's rights advocate, another prosecutor, and another victim's rights advocate. So there are no witnesses present.
That's correct.
All right, one moment, please. The court is going to pass this matter for a moment, and I need to recall another matter just briefly. We'll be right back. The court will recall the case of the people of the state of Michigan versus Britton Keith Aldrich, 21-39217.
Yeah, they on some bullshit. A year
Sorry,
probation.
Mr. Hill.
Man, fuck yeah.
Mr. Hill, you can still be heard.
Thank you. Thank you.
Thank you. The court is in receipt of the case of the People versus Gayhart, case number 776 Northwest 2nd 330 285 Mishap 202, a 2009 case. Mr. Brown, I know that you just received this matter as this case also. Do you have any additional arguments based on your review of that?
Yes.
Thank you. You may proceed.
That's prosecution finished. Yes. All right. Well, the prosecution is attempting to bootstrap separate and completed misdemeanor committed out of the jurisdiction of this county into this county. So they can upcharge from misdemeanor to felony. In defense of that, or by way of trying to complete that, they present People versus Gayhart, speaks of murder that was committed in Michigan, and the body was found in Indiana. What that talks about is a felony that is pre-planned, that there's premeditation to kill a person, and one state and to another state. The difference here,
Microphone.
what distinguishes this case is this isn't some pre-planned offense, some ongoing offense. This is a fully completed misdemeanor. This is something that if we believe the testimony of the planning witness, my client acted in anger and was kicking. There's no long ongoing plan to do anything other than act in frustration, which resulted in the smash in Wayne County before the big wheel. That was probably what, not Westland.
Dearborn.
Warner. But anyway, so that's complete, that's done. That's a misdemeanor, that's a completely separate offense. And that's what's going on. What's going on here is they're not trying to melt the offenses so much. They want to melt the costs. They want to take the cost of a separate and completed offense and add it on to a different separate and completed offense, which ties to slash yard and her. This is not the same offense. They're not an ongoing premeditated scheme of putting something. One is allegedly kicking the windshield out of frustration and anger. Another is an attempt to try to keep her points in there.
just so happens it happened to the same vehicle, but they're not the same things. And there's no reason why the two costs should be added together when one of them clearly occurred and was completed in an entirely different jurisdiction. What Gayhart speaks to is a premeditated plan to complete a full act. In this case, it was a murder. Here we have two separate misdemeanors, and the only thing that links them up is they happen to have been committed against the same vehicle, but they're two separate things. They're two separate occasions. If I smashed out someone's windshield on Thursday and then came back the following Thursday and did something else to it, and completed that offense and got charged with it or whatever, it's still not the same ongoing. It's not the same thing, especially if I did it in a completely other jurisdiction where they have the ability to be able to prosecute, and so they still would have that ability to prosecute. So I would say that the prosecution should not be allowed to join these two costs for two separate events. I don't think Gayhart allows them to do that.
Thank you very much.
I believe part of the issue, or the way I'm interpreting it from counsel's argument, is whether or not we can look at the aggregate of the damage done. So counsel is arguing that they should be separate incidents, and had the windshield incident been it, there was no more destruction of that vehicle, then I would actually agree that it was out of jurisdiction. But here we have a situation where there was damage done and that continued. So if we're talking about, specifically in this case with malicious destruction of property, aggregate, that would fall under MCL 750-377A2, subsection 2, which reads, the amounts of destruction or injury in separate incidents pursuant to a scheme or course of conduct within any 12-month period may be aggregated and determine the total amount of destruction or injury. So I would disagree with Mr. Brown that if he, damaged property and then came back the next day, next week and continued that damage, that wouldn't be an aggregate. That in this situation, clearly statute accounts for that, and certainly we could take into account damage that was done to the same vehicle with the same malicious intent to the same victim, same evening, possibly a few hours at most. So we argue that in that sense, they should not be treated as separate incidents, but rather it's a course of conduct and certainly falls within that 12-month period.
Thank you. The court has reviewed the case of People versus Gayhart as well, and I do not find that it is dispositive of this particular issue in that particular case, there was a plan of action, and the motivation and the planning and the actual murder occurred within the state of Michigan, whereas the burial of the body occurred in a different place. The premeditation and the sequence of events that led to that situation is very different than here. In this particular case, the parties were in the midst of a heated dispute, and Mr. Britton kicked the window out. Mr. Aldridge kicked the window out while he was in Wayne County, clearly in Wayne County. And depending on how the events had occurred that night, he may not have kicked another window out. It just so happened that he kicked that window out, and then later on he did do damage to the tires. I think that the prosecutor is correct that the situation could be aggregated if it occurred within the same county. It did not occur within this jurisdiction, and therefore it is not a part of this particular action. So the case can be addressed, but as a misdemeanor, not as a felony. So therefore, I do not bind over, I do not allow the prosecution to amend to add the count 6. I will keep the remaining malicious destruction of the Jeep as to the tires, which occurred in Washtenaw County, which is count 3, and count 4 will be removed, and there will be an added count 5, as I indicated earlier with respect to the destruction of the building. Thank you. The court will enter the plea of not guilty and bind over as to counts 1 and 5. And the remaining counts will tag along with that. The pretrial in this case will be August 2nd, 2021 at 1:30 before Judge Patrick Conlon. August 2nd, 2021 at 1:30. Bond is continued.
Thank you, Your Honor.
You're welcome.
Thank you, Your Honor. We appreciate it.
Thank you. Here are the exhibits. I don't know if you need those back. Thank you all for the insight with all the case law today. Learned a lot. All right, the court will go back on the record in the case of the State of Michigan versus Douglas Eugene Hill, case number 21 FB 1594.
Thank you. Amy Reiser again on behalf of the people.
Thank you. Mr. Gaddy.
Mike Gaddy, Assistant Public Defender on behalf of Mr. Hill.
Thank you. All right, you may continue with Ms. Nelson's testimony.
Thank you. You did swear her in. Did she state and spell her name?
She did not state and spell her name.
Ms. Nelson, would you state and spell your name, please, for the record?
Shakira Nelson, Shakira, Nelson, Nelson.
Thank you, ma'am. My name is Amy Reiser, and we met earlier this morning, and I'm going to ask you questions. If anything is sort of delayed because we're on Zoom, please just let me know and I can repeat the question if you don't understand it. They will still, from this recording, make a transcript. So sometimes witnesses like shake their head yes or no, but we do need a verbal response. So the clerk will be able to prepare a transcript. And when I'm done asking you questions, Mr. Gaddy will ask you a series of questions and the same rules apply. If there's anything he asks you that you don't understand, just let him know and he can repeat it. And if at any time you need to take a break, let us know. So can you tell me, I want to take you back to May of 2021. Were you living on an address 2802 Apple Ridge Street in Ypsilanti Township, Washtenaw County?
2802.
2802.
Yes.
Is it, am I pronouncing it right? Apple Ridge? Okay,
Yes.
Just a little delay there. And who were you living there with?
I was staying with one of my coworkers. Her name is Aaliyah Tate.
Okay. And was that like were you temporarily staying with her or were you a roommate? What was the situation?
I was temporarily staying there. I had just recently lost my own place of living, and in between me waiting for the place that I'm currently in to be ready, I was staying with me.
Okay. And where do you work at that you knew Aaliyah from work?
I work for Ypsilanti Community Schools.
Okay. Okay. And while you were staying there, did you?
Your Honor, I believe that her, excuse me, I believe that her, Ms. Nelson's camera went out.
I believe it did as well.
I was trying to get it back.
Ms. Nelson, one moment, please. Ms. Nelson, one moment, please. That sometimes the camera does have to go out in order for the video feed to actually be able to take up to hear the testimony. So that may have to occur in this environment, Mr. Gaddy. Are you objecting to that?
Yes, Your Honor. I mean, we're on Zoom, which is, great technology, but I still think we need to be able to judge body language and things like that.
Any response? Ms. Reiser?
No, Your Honor. I mean, I think it's a bandwidth issue. So I think when she's speaking, we're not able to hear her, but if she's able to shut her screen off, then we can hear what she's saying because of the internet connection.
I believe that the prosecution is correct with respect to that. So
Yeah.
is your
I just
client
don't,
hearing via Zoom without objection? He did schedule this for a Zoom hearing, correct?
He did.
that is correct, Your Honor. I believe it is scheduled here via Zoom.
All right, thank you.
However, it's scheduled via Zoom working properly, not, I mean, you know, Zoom in the vast majority of cases entails, you know, it's different from a telephone in that we can see each other and hear each other both at the same time. You know, technology that we didn't have a couple of years ago for the most part. So to the extent that, you know, he did it, you know, I believe this was scheduled for a Zoom exam. However, I don't think that it was scheduled for a phone exam, which is what this turns into if the camera isn't working.
Well, Zoom can actually be via phone. People can call in. So technically, she could have called in today and testified.
I'll just note my objection, Your Honor. Like I said, I don't know if her not being, I mean, Zoom is typically people being on the screen. You know, testifying without that, you know, it becomes not that. You know, and if this is, if the standard for a Zoom exam is that she could have called in and testified without any facial or without any camera, then you know, I don't necessarily know that we would have waived to that, or we would have agreed to that.
All right. Additionally, I can't see your client either because he's in the dark.
Can you turn on a light, Mr. Hill? There we go.
Thank you.
And he's sideways. I don't know what's up with that.
All right, thank you. We will continue to try to see if we can get the testimony so that I can hear her. If we are unable to hear her and there is an objection to seeing her, then we may have to have this done in person. It's the only thing I can think of to satisfy any objection. Ms. Reiser?
Okay, we'll continue. Ms. Nelson, can you hear me?
Yes, can you hear me?
Yep, that's better. So you were living temporarily at the Apple Ridge address with your coworker because you had lost your own housing?
Yes, ma'am.
Okay. And so did you know the defendant Douglas Hill?
I did once I moved in, but not prior to moving in.
Okay, so when you moved in, you met him, and what was his relationship to the homeowner?
I believe he's like her nephew or her godson. I just know that she's been present in his life since he was a child, so.
Okay, and the individual that you met and came to know as Douglas Hill, do you see him on the screen, on the Zoom screen?
Yes, I do.
Okay, and can you tell us what he's wearing?
It looks like a black wife beater.
The record could reflect she's identified.
Objection to the characterization, Your Honor.
He's objecting to the characterization of the type of t-shirt that he is wearing today.
Oh, could you explain what you mean by wife beater, Ms. Nelson?
No, I don't want an explanation of it. Or could you identify it in a different way, Ms. Nelson, please?
He's wearing a black tank top, red shorts.
Thank you. And appears to have a video game controller in his hand.
Yeah. So I'm going to take you to May 2nd, the early morning hours of May 2nd, 2021. Were you staying at that address?
Yes.
Okay. And did Mr. Hill live there, or did he come there to visit, if you know?
I think it was like an off-term living situation. He was there quite often, but I wouldn't say as often as I was.
Okay. And so Saturday evening, May 1st, going into the early morning hours of Sunday, May 2nd, can you tell us what you were doing at the residence?
At the residence at that time, I had come in from spending the day with my child's father. I had to, I guess I just took a shower that day. I went into the bedroom to go to bed, the bedroom being that of Aaliyah Taylor's, her son. He had went to spend the night with a family member, which left his bed free and available. I usually slept on the couch or with Aaliyah Taylor's daughter. So opposed to sleeping in bed with another person or on the couch, I decided to take her son's bed.
And he was gone for the night?
Yes, he was gone for the night.
Okay. And when you say your child's father, can you explain who your child is?
I am currently pregnant. I'm 27 weeks tomorrow. So when I say my child's father, the man who impregnated me, that's who I'm referring to.
Okay. And so you mean your unborn child?
Yes, my unborn child.
Okay. So you went to bed in the son's bedroom. At some point, did the defendant come in there?
Yes, he did.
And do you recall like approximately what time it was?
I would say maybe around 3 a.m., maybe a little earlier.
Okay. So as 3 a.m. on Sunday, May 2nd.
Correct.
Okay. And what happened when he came in?
When he came into the bedroom, I was laying on my stomach, and Mr. Hill, he initially started to kind of like massage my body. And into that action, I didn't reject it. I didn't oppose anything of that nature. It wasn't until the massage, he tried to progress it, and he tried to pull my shorts down. When he tried to pull my shorts down is when I first started to object to him and tell him no, that, this isn't what I wanted.
Okay. So he starts to pull your shorts down. And what part of his body is he using to pull your shorts down?
He's using his hands to pull my shorts down. He's like, it's more of like a simultaneous action where he's trying to pull my shorts down and turn my body over. Because as I stated, I was originally laying on my stomach.
Okay. And you're verbally telling him no?
Yes.
Okay. And what, if anything, are you doing with your body?
With my body, I am trying to go against Mr. Hill's actions, trying to block and pull up my shorts as he's trying to pull them down. And I feel like eventually it was a matter of him not wanting to wrestle with my shorts anymore. Well, in a matter of pulling them down, because he just kind of pulled them to the side. And that's when he used his, I guess, other extremities, meaning his legs and his arms, to kind of pin my body parts back. He had a forearm here, like on my rib cage area. I ended up with bruising there. And I also ended up with bruising on the inside of my legs from where he was holding me down and trying to pull my shorts apart to cause penetration.
Okay. And so at that point, did he have you on your back?
Yes, ma'am.
Okay. And what, if anything, is he saying to you?
He is, in the beginning, there wasn't much that was to be said by the defendant. But as I started to tell him, no, I don't want this. This isn't what I want. Stop. He started to ask me very specific questions. Do you like it? How does this feel? Things like that.
Objection.
And
What's the objection?
Sorry, Mr. Gaddy. Objection to hearsay?
Yes.
All right. The objection is hearsay.
Your Honor, that's a statement made by a party opponent, specifically the defendant in this case.
Thank you. I agree. Overruled.
Thank you.
Thank you, Your Honor.
So you're telling him no, Ms. Nelson, and he's asking, do you like this? Do you like this?
Yeah, he's asking me, do you like this? He was asking me if he could do sexual things to me that I kept repeatedly responding no to. I kept repeatedly responding stop. I never stopped fighting or trying to push him off of me. So, yeah.
And he was physically holding you down with his body?
Yes, ma'am.
Okay. And what happened next?
Afterwards, I'm not sure if he ejaculated or if he just decided that he was tired of the fight. But Mr. Hill, he just kind of stopped. And when he stopped, he began to ask me if I was okay. I would say he asked me a good 3 times before I walked out of the room with my belongings. And yeah, when I walked out of the room, I went into another bedroom that held my clothing. I changed my clothes. I went and I locked myself into the bathroom. I texted a best friend of mine and told her that I needed a hospital and that I felt I had just been assaulted. And I felt that the defendant had been drinking, and I don't believe that he was believing me when I was telling him no or asking him to stop.
I object. Objecting to the drinking comment. Objection to the drinking comment. You know, she said she felt that the defendant had been drinking. That would be call for speculation, and this is a narrative. The question was asked a long time ago.
Thank you. So Ms. Reiser asked to the speculation and narration.
I can clarify on the drinking part, but I do. So Ms. Nelson, before leaving the room and going to the bathroom and those steps you took after that, did he actually penetrate you with a part of his body?
Yes, with his penis.
Into what part of your body?
My vagina.
Okay. And were you continually telling him to stop?
Yes, I was telling him to stop. I was telling him this isn't what I wanted. I was telling him, I was continuing to push him off of me, or at least attempting to. Yeah.
Okay. And you mentioned that you thought he had been drinking. And can you tell us what led you to that belief?
We were in the same home. I seen him drinking.
Okay.
Mr. Hill also works at a bar where before he leaves, has a drink or two.
Objection, calls for speculation. She doesn't know what he does at the bar unless she's there.
Okay.
Response, Ms. Reiser.
I think she can testify what led her to believe that he was drinking, what characteristics he was exhibiting, or if she saw him drinking.
I agree with that, Ms. Reiser. She's now testifying about something he did outside of her presence. So that is speculation.
And if I could just ask one clarifying question, do you know, Ms. Nelson, from your own information, if he had been at work previous to coming to that residence on Apple Ridge?
Yes, from my knowledge of Mr. Hill's work schedule, yes.
Okay. And did you see him consume alcohol in the Apple Ridge home that evening?
Yes.
Okay. Could you smell alcohol in his breath?
Yes.
And anything else that led you to believe that he had been drinking?
There were liquor bottles there. I seen him drinking. There's not much to lead me to believe it. I seen it.
Okay, thank you. And after you sent this message to your friend, did she come and pick you up and take you to the hospital?
Yeah, she messaged me and let me know that it was late. So she was like, okay, give me a chance to put my clothes on and I'll be there to come and get you. She texted me when she was on her way. She texted me when she was outside. When she texted me and told me that she was outside, I left the residence. I got in her car and she drove me to St. Joe's.
And there, did you undergo a sexual assault exam by the nurse?
Yes, I did.
Okay, and did you also tell her what happened?
Yes, I did, but not with all of the detail.
Okay. And were you ultimately interviewed by the police?
Yeah, a few officers, yes.
Okay. Thank you. I don't have any other questions for this witness.
Thank you. Your witness, Mr. Gaddy.
Ms. Nelson, you testified that you were staying at the, sorry, I got my notes here. Okay, sorry. You testified that you're staying at the 2802 Apple Ridge address. Is that correct?
Yes.
On May 2nd?
Yes.
How long had you been staying there at the time?
I would say like the middle of February or so, like the beginning, mid-February, I moved in.
Mm-hmm. And you said that Mr. Hill's godmother lives there?
Yes, she rents the home.
Uh-huh. And what's her name?
Aaliyah Taylor.
Who else lives there?
I guess her partner or her boyfriend, he was there at the time, and she has 2 children, a son and a daughter.
How old are they?
At the time, her daughter was 15, and I believe her son was 9, maybe 10.
Okay. And what time did you get home on the 2nd?
I'm not sure. I would say that I got home pretty late, though. I would say at least after 11 p.m.
Okay. And what time and you said Mr. Hill came home at some point, or was he home when you got there? Or was he at the address when you got there?
I believe Mr. Hill was already there when I arrived that night.
Okay. And when you got there, did you immediately go take a shower, or did you sit and did you immediately go take a shower?
No, earlier that day, I had been a few places with like shopping. So I went and I put some things away, that kind of thing. I socialized in the living room with Mr. Hill and Mrs. Taylor for a little while. And then I went and took a shower and laid down. So it was a while before I actually went to bed.
Okay. Yeah, you testified that you were with your soon-to-be child's father, is that correct?
Correct.
And what's his name?
His name is Marcus.
Marcus what?
Williams.
Okay. And so let's describe, so when you got home, you said Miss Taylor was there. Do you know where she was when you got home?
Her living room and dining room and kitchen area is kind of like one big open space. So she was in that general area.
Okay, and where were her kids?
Her daughter was in her bedroom and her son was not home. From my knowledge, I was told that he went with an aunt.
Okay, and where was her boyfriend?
He was not in the residence either. When I got there, Mrs. Taylor was actually pretty upset and distraught that he wasn't home and she was looking for him.
Okay.
So I'm not sure where he was.
Okay, you're breaking up on me a little bit there, but I made it out. Okay, and so is this a 1-story or a 2-story house?
This is a 1-story house. There's no upstairs.
Is there a basement?
No, there isn't.
Okay. And how many bedrooms are there?
There's 3 total.
Okay. And how many bathrooms?
Was that how many bathrooms?
Yeah.
There's 1.
Okay, so we've got, now is there a separate dining room from the kitchen?
No, the kitchen area and the dining room, they're kind of, the kitchen area, the dining room, and the living room, they're all like one big open space. The only thing that would be separated from that, she has like a smaller laundry room that's kind of separate.
Okay. All right. And do you know how many square feet this house is?
I have no idea.
Okay. Would it surprise you if it was about 850 square feet?
Again, I don't know.
Okay. And so you testified that you came in and you sat down and talked for a while. How long did you talk?
I'm not sure, a little while. I would say at least a couple of hours. Because it was long enough for me to converse with Aaliyah. And like I said, she had disclosed to me that, you know, her boyfriend hadn't come home. He had the vehicle, that kind of thing. So we discussed that for a while. Her daughter, the 15-year-old, she came out to the table and conversed with us for a while as well. So
she came out to the table or the living room? You just said you were in the living room. Were you in the living room or the kitchen or the dining room?
I just said that all of it is connected and it's all open. So depending on where we were at the time, I would be sitting at the table. Aaliyah was back and forth in between her living room and her dining room. When her daughter came out, she was pretty much, I would say primarily at the table until she went back into her room.
Okay. And what time did you go to take a shower?
I'm not sure. I would say after 2 a.m.
Okay. All right. And then you said you went to bed, right?
Correct.
All right. And you testified that you went into Miss Taylor's son's bedroom?
Correct.
Okay. So if you're in the house, okay, let's say in the living room, okay?
Correct.
Is there a hallway to the bedrooms?
Yes, there is.
Okay. Is this bedroom, are the bedrooms right in a row, or are they, space, or are they on opposite sides of the hallway, or what?
There's one bedroom on the front end of the hallway. The bathroom would be in the middle, and the last 2 bedrooms would be on the end of the hallway.
Okay, so you're testifying that you were in the front bedroom then, the one closest to the living room?
Correct.
Okay. And how far is that bedroom from the living room?
It's right off of the living room, like the hallway. So you would turn off of the living room, and as soon as you jump into the hallway, I would say there's the only thing that would separate that would be like I said, the laundry room, and there's a hall closet there.
Mm-hmm. And okay, and did you have any all right, so when you went into that, in the bedroom to go to sleep, was everybody else in bed, or were they still up?
Yeah, everybody else was pretty much in bed for the most part. Aaliyah hadn't gone to her actual bedroom. Aaliyah was asleep on her couch, and her daughter went to her bedroom.
Okay. And what's the daughter's name?
Asia.
Is Asia's bedroom then, if you were to exit the bedroom you were in, is her bedroom to the left?
If I were to exit the bedroom that I was in? If I were to exit the bedroom that I was in and go down the hall to the other 2 bedrooms, Aaliyah's room is on the left, Asia's room is on the right.
Okay. But you would turn left out of the bedroom you were in to get there, correct?
Correct.
Okay. And how far is that bedroom from where you were, from the bedroom you were in? Could you guess how many feet?
I don't know.
How many steps?
I would say maybe 20 steps or so, maybe 20 to 30 steps or so.
20 to 30 steps. Okay. Okay. 20 to 30, you're saying? Okay. And you testified that you would come in and you'd been with Mr. Wilson, correct?
No, Mr. Williams.
Williams, I'm sorry. And you had, and when you left him, were you guys getting along, or were you in an argument?
We were getting along fine.
Mm-hmm. Okay. And you testified that you were laying on your...
I'm sorry, you broke up.
Yep, I'm sorry, I'm turning this off. Okay. Okay. You testified that you would come home. Did you drive, or did he drop you off?
Marcus dropped me off.
Okay. And you testified that you took a shower and then you went and you were laying on your stomach
Yes, sir.
in the front bedroom, correct?
Yes, sir.
Okay. And you testified that then Mr. Hill came in and was the light on or off?
The light was off. I was headed to bed.
Okay. Was the TV on or were you listening to music or anything?
The TV was on, but there was nothing connected to it. So Mrs. Taylor doesn't have cable, and we primarily use the game systems. So if the game system wasn't on, it would just kind of be like a blue light on the TV. So the TV was on,
Okay.
but there was nothing playing. There wasn't anything on it.
Okay. And you testified you were sleeping, correct?
Not at that point. I was headed to bed. I was on my way to sleep.
Okay. And how long had you been in there when he came in?
I would say at least 30 minutes or so.
Okay. And you testified that he began to give you a massage?
Correct.
And this was okay with you?
Yes, it was.
Okay. And then you testified that he attempted to roll you over and pull your shorts down at the same time?
Correct.
Okay, let's talk about this bedroom. How many beds are in this room?
There's one.
There's one bed? Okay, is it a twin size bed, a full size bed, a queen size bed?
There's one twin size bed.
Okay. And when you walk into this room, where's the bed located?
If you walk into the room, directly ahead of you, across the room, is where the bed is located. In the center of the room is a dresser, and on the right wall of the room is a dresser. So on the front wall in the bedroom is where the twin size bed would be.
Okay, is there a desk and chairs too or anything like that?
There was like a gaming chair that Mr. Hill and Aaliyah's son would sit in to play the game. As I said, they were on each one of those dressers. There was one up against the wall and one up against the back wall. Each one of those dressers had a TV. Mr. Hill would play the game on his own TV and her son would play the game on his TV. So at any time, there may have been a chair or two in the room for either one of them to sit in to play the game or watch TV or whatever.
Gotcha. Okay. All right. And you said eventually he pulled your shorts to the side?
Correct.
Okay. And that's when he then penetrated you. Was that your testimony?
Correct.
Okay. And you testified that you said no and stop?
Yes, I did.
Did you say this in a normal tone of voice or was it audible?
It was audible and it wasn't a normal tone of voice. It was stern. It wasn't, hey, please stop. It was more stern. It was a seriousness to my voice.
Okay, and you were yelling?
I would say that I was.
Was the door open or closed?
The bedroom door was closed.
Had you closed it?
When I originally went into the bedroom, yes, I did. When Mr. Hill came into the bedroom, he obviously opened it to enter the bedroom and then he closed it behind himself.
Okay. And you testified you didn't know if Mr. Hill had ejaculated, correct?
Correct.
Okay. And did you testify as to how long this went on?
I'm sorry, what was that?
Did you testify as to how long this went on?
No, I didn't.
Okay. And then you testified that you got up and went to the bathroom. Is that correct?
Yes.
How far is the bathroom from this bedroom?
Well, you missed a part of where I testified. I said I went into.
No. Oh, I'm sorry. you testified that you went into get some clothes to another room. Is
And
that
then
correct?
I went into the bedroom. I mean, and
Which
then I
room
went
did
into the bathroom.
Okay, I'm sorry. I forgot which room you went into to get clothes.
I went into Asia's room, her daughter's room, the room on the end right of the hallway.
And was Asia awake or sleeping at the time?
That I'm not too sure of. Asia, she has a friend that she likes to fall asleep on the phone with, like on FaceTime. And the phone was on, that kind of thing, but there was no light on when I went in the room. So I'm not sure if she was still on the phone with a friend conversing or if they had fallen asleep on the phone together, but there was no light on. There was nothing on to indicate that she was awake.
Okay, and where were your clothes on? Where were your clothes in the room when you went in there?
When you walk in her room and immediately turn to the left, there is a little plastic, like 3-set drawer that had some of my clothes in it, and then also in her closet.
Mm-hmm. And did you have any, okay, and so how long were you in that room?
I would honestly say literally seconds. I grabbed an outfit that was a matching top and bottom. So I just grabbed a track set and walked back out of the room.
And did you say anything to Asia?
I did.
Oh, you broke up on me.
No, I did not speak to Asia.
Okay. Did she speak to you?
No, she did not.
Okay. Did you turn the light on?
No, I used my phone for like the flashlight.
Okay. Was the door open or closed when you went to it?
Asia's door is primarily closed all the time, so I had to open her door to go into it.
Did you knock?
No.
Okay. So you went from Asia's room to the bathroom, correct?
Correct.
And how long did you how long were you in the bathroom?
I would say I was in the bathroom for about maybe 15 to 20 minutes.
Okay. And did you and then your friend you called your friend? Who's your friend?
I didn't call her. I texted her, and her name is Kayana Chapman.
I'm sorry, you texted your friend, and how long did it take her to? And you testified she came and picked you up, correct?
Correct.
Okay. All right. Did you wait in the bathroom for her?
I'm sorry?
Did you wait in the bathroom for her?
Partially, I did. I received a few text messages of her giving me like her up-to-dates on where she was at in the process of coming to get me. And what I mean by that is she texted me and said, okay, I'm gonna put my clothes on. Hey, I'm headed out. Hey, I'm 5 minutes away. When I got the text message that she was about 5 minutes away, that's when I proceeded to leave the bathroom, because shortly after that, she texted me and told me that she wasn't able to read the numbers on the houses because it was so dark. So that's when I proceeded to leave.
Okay. And so for that 5 minutes, where did you go?
I went, and Aaliyah has kind of like a chase lounge, I guess you will call it, in her living room. And I sat on the chase lounge until I felt like I seen headlights.
And was Aaliyah still up at the time?
No, she was out of there. No, she was sleeping.
Was she sleeping in her bedroom or in the living room?
She was sleeping on the sofa in the living room.
Okay. So you didn't talk to her either?
No, I didn't feel comfortable talking to Aaliyah.
Okay. Did you ever go back into the bedroom after you were in the bathroom?
No.
Okay. All right. And then your friend came and took you to the hospital?
Correct.
All right. And there they did an exam?
Yes, they did.
And so and did you speak to a nurse and tell her what you had just testified to?
Yes, I spoke to I believe it's called a triage nurse, the one who lets you, like the initial person that you talk to when you get to the emergency room. I spoke with a triage nurse, and that's when I initially let her know that I felt as if I had been sexually assaulted and that I was 15 weeks pregnant, and I wanted to get myself checked out and also check on the health of my child. But I did not release Mr. Hill's name at that time.
Okay. Did you tell her that it had been Marcus who did this?
No, I did not. When my friend,
I just asked a yes or no question, ma'am. I just asked a yes or no question. Okay.
No, I did not.
And you spoke to the police about this, correct?
Yes, I did.
Okay, and you spoke to them and you understood that that once you were speaking to them, they were gonna do an investigation, right?
Yes, I did.
Okay, and do you believe it's important to tell that when you're speaking to the police and they're doing an investigation, that you should tell them that you should try and be as truthful as possible?
Yes.
Okay. But you didn't tell the police immediately that you believe Mr. Hill had done this, correct?
No, I didn't.
Okay. And did you tell the police that Marcus had done this?
No, I didn't.
You didn't. Okay. Okay. And you were of sound mind that night. You hadn't been drinking, correct?
No, I was 15 weeks pregnant. No.
Okay. You hadn't been using drugs or smoking marijuana or anything?
I do smoke marijuana, yes.
Okay. But you're of sound mind at the time, correct?
Yes.
Okay. All right. So you weren't intoxicated?
No, not at all.
Mhm. And would it surprise you? Now you said that you had bruises. Would it surprise you that the medical reports don't say anything about bruising?
No, that wouldn't surprise me.
Okay. Your Honor, could I have a short breakout room with Mr. Hill?
Yes, you may.
Thank you. Thank you, Your Honor.
All right.
Okay, so ma'am, she went to the other side.
Ms. Nelson, are you present?
There she is. Okay, sorry about that, Ms. Nelson.
I'm here.
Okay. When you went to so let's go back to when you testified that you were laying down. Who was in the room first, you or Mr. Hill?
I was.
Uh-huh. Okay, and you said you were there for about a half hour before he came in?
Yes.
Okay. And okay. All right, and you testified that he came in and started massaging you, but you didn't. There was no conversation before he massaged you. How long was he in the room before he started massaging you?
That I'm not sure of. I know that he did something like with the TV. I'm not sure if he was playing the game or like trying to find a movie or something of that nature. So I'm not sure how long he was in the room.
Okay. So he was doing that with the lights off?
Yeah, you just have to press a button, so it doesn't require much.
Okay. Okay. And other than saying no or telling him to stop while he was turning you over, did you have any other conversation with him? Oh, she's gone.
Ms. Nelson, could you please turn your camera back on? Ms. Nelson, are you present? Ms. Nelson, are you present?
I don't wonder if her battery died. She's been on it since 9 this morning. Oh, there she is. Okay, tell her to sit down.
Hello, Ms. Nelson?
Can you hear us?
Ms. Nelson, can you hear us?
Can you hear us, Ms. Nelson?
Can you speak to us, Ms. Nelson?
Can you hear us?
We can't hear her.
She's talking, right?
We can't hear you.
We can't hear you. We can't hear you.
Do you want to try to have her sign in, sign out and sign back in, Ms. Reiser?
Sure. Can you try to sign out and sign back in? Oh, there's the mute button. Can you hear us now?
Are you able to call her? Do you have her phone number, Ms. Reiser?
Yeah, can you call her?
I spoke to her. She's going to sign out and sign back in.
Thank you so much.
Thank you, Julia.
Is that better?
Yes.
Yes, it is. We can hear you again. All right. Mr. Gaddy, please repeat your last question.
Been a while. Oh, so you testified that we were talking about who was in the room first, and I believe you had testified that Mr. Hill had done something with the TV and the lights were out and he had just pushed a button. Do you remember that?
Yes.
Okay, so that's where we were. Okay, did you and he converse about anything before he started? Now you testified that he started massaging you. Is that correct?
Correct.
And did you and he converse about anything before that?
No, there were no words.
Okay. Okay. And I have nothing further, Your Honor.
Thank you. Your witness, Ms. Reiser, any redirect?
No, Your Honor.
All right, thank you. May this witness be excused.
She may be excused, Your Honor, although I would like her to remain on just to address the issue of bond.
Thank you. All right. Any further witnesses as to this matter, Ms. Reiser?
No further witnesses.
All right. Any witnesses from the defense?
No, Judge.
All right. Motion from the people.
Yes, Your Honor, we would move for bind over on count one in the felony information. I do believe that Ms. Nelson's testimony does provide probable cause that a crime was committed and that this defendant, Douglas Eugene Deshaun Hill, did commit the crime of criminal sexual conduct in the third degree. He did engage in sexual penetration with Ms. Nelson using force or coercion to accomplish a sexual penetration. We would ask that based on her testimony, the force that she described, her repeated attempts to stop him both verbally by telling him no and trying to push him off her, that you would find probable cause and bind the case over to circuit court.
Thank you. Response.
Yes, Your Honor. This court is allowed to assess credibility in these matters. This is a house that is a 3-bedroom, 1-bathroom house with a living room. There was at least 2 other people in the home. One 20 steps away, apparently, and the other in the living room right next to the bedroom. Ms. Nelson testified that she was stern and that she yelled, and yet apparently nobody else was able to hear her. We'd ask the court in assessing this testimony to not bind this matter over. I don't think the people have met the elements of the crime.
Thank you. The court has heard the testimony that was provided today. Ms. Nelson did testify that she had indicated to the defendant when he came in the room that she did not want him to do that. She did not want it to occur, and that he did penetrate her by after attempting to get her pants and panties down. Her panties down. He then just moved them to the side and used his body parts to actually force penetrate her. She indicated that there was bruising. That testimony, although is a question of fact for the jury at this point in time, we believe that it is probable cause to be bound over as to the criminal sexual conduct in the third degree charge. Matter is bound over to the circuit court.
In terms of reading of the information, I would acknowledge receipt of it. Ms. Reiser will be the same one that's attached to the other stuff, correct?
Correct. I'm going to try to electronically send it this afternoon to you. And
that's fine. I'll acknowledge receipt of it. I have an unsigned copy. We'll waive reading and stand mute, Judge.
All right, thank you. I will enter a not guilty plea to finding on count 1 criminal sexual conduct, which is a 15-year felony with mandatory AIDS and AF testing. I am signing an order at this point for the testing.
Thank you.
The pretrial in this matter would be, well, I guess we need to address bond first.
In general, I would like to address bond. I believe the defendant's bond is set at a $50,000 PR bond, and I have serious safety concerns for the victim in this case. As I indicated to Your Honor and to Mr. Gaddy prior to the beginning of the examination, immediately within days of the victim reporting this, she started to receive text messages. The first was on Thursday, May 6th, stating, "We stomping that bastard out of you," within a celebration emoji, presumably referring to the unborn child that she's carrying. The second text received on May 8th said, "You ready to join your daddy, bitch?" And the victim can certainly elaborate on that her father is deceased. She's continued to receive text messages from unknown numbers that are not traceable, like a spoof number. On June 20th, she received a series of text messages that said, "Tell me how it feels to be your last week alive. Your baby will suffer very slowly after we cut that bitch out of you, and you can't hide." She responded, "All of this is being added to the report that's going to be called on the 20th. Please continue." And the response was, "LOL, wait until we catch you." She was receiving text messages last week on the 16th, and I can certainly let the victim elaborate, but now that she has testified, I'm very, very concerned for her safety.
All right. Are you calling her as a witness at this
I
point?
am. Ms. Nelson, would you please unmute? Do you need her to be sworn in again, Your Honor?
Ms. Nelson, you are still on oath.
Thank you. Can you explain to the judge the text messages that you've been receiving most recently? Those would have been last Friday, July 16th and July 15th, and throughout the pendency of this case since you reported it to the police.
Yes, I can do that. I just want to make sure that it is okay that my screen is going to pause for a second so I can go to the actual text messages. Is that okay?
They're on your phone?
Yeah.
Yes.
Your Honor, I guess I would say that if the text messages are, there's been a lack of foundation in their hearsay.
It's a bond hearing.
With respect to the hearsay argument, I agree with the prosecution that it is a bond hearing. With respect to the foundational argument, I do believe that we need to have something on the record as to the foundation that these are coming from the defendant.
So I don't have any forensic evidence that they're from him, except the context, the timing of the text in relation to the court hearing, and what Ms. Nelson would testify to.
Any response?
Your Honor, I mean, these are texts presumably from numbers that Ms. Nelson doesn't recognize, that Ms. Reiser doesn't recognize, that are not attributed in any way, shape, or form at this time, or by the officer or by the office. Well, one of them is part of a police report, and I don't see any attribution there. or any nexus to Mr. Hill. So I would object to those, Your Honor. There's 350 million people in this country. I don't, and there is, Ms. Reiser has talked about, there's other people who may or may not be involved in this. This matter goes beyond, I believe, these allegations here today. So of all the people that she knows, while there may be a coincidence or something that it came whenever the close to the court date, as she stated, I would still object to the foundation. I don't think there's anything that can trace this that can in any way connect this to Mr. Hill.
Thank you. The court believes that there is no connection to Mr. Hill. However, at this point, the court will hear the testimony from Ms. Nelson as to what those particular text messages are, and you can make arguments as to the next. I think that goes to the actual value as opposed to the actual existence. So they exist. The question is whether or not they can be connected to him. And so I will hear the testimony as to them and make my ruling based on that.
Thank you.
All right, Ms. Nelson, you received text messages. What were they, ma'am?
I have been receiving text messages from the beginning, and actually in response to Mr. Hill's lawyer saying that none of them came directly from his number. That is not true. In the very beginning of this, I did get a text message directly from Mr. Hill, and it stated, "You a foul bitch, and you better hope the police catch him before I do."
I'm going to object to this testimony. The text messages that I've been informed of and that I've received are two that were in the police report and one that was sent to me today. I have no prior knowledge of this text, of any text that Ms. Nelson is speaking of.
Ms. Reiser, has that information been shared, Mr. Gaddy?
I will, Your Honor. There's going to be a separate investigation for witness intimidation. So as soon as I have it prepared, I'll send it to him.
My question was, have you shared the prior to this moment so that he's aware of this text that apparently Ms. Nelson is testifying about?
No, Your Honor, these have been like coming in. She's sending to the advocate. She's sending them to the investigator. One has been supplemented out. The investigator's leaving the department, so the others haven't been supplemented out. I did tell him last night when we spoke on the phone about today's case that his client had been sending threatening messages to the victim.
Right, but she's testifying now about one that is directly connected to him, which I was not aware of until now. And I don't think he was either. So my issue is that in order for him to properly defend his client, he has to be aware of what the allegations are.
So no, I've only sent him the two text messages.
Were you aware of this one that she's referring to right now?
I don't know. I don't believe so.
Right. Ms. Nelson?
Yes.
Can I see the parties? Can I see the attorneys in the breakout session, please? All right, we're back on the record in the matter of Douglas Eugene Deshaun Hill. The court is going to set this matter over on what would normally be an in custody date so that the bond issue can be addressed. I did speak to the prosecution regarding making sure that the defense has a copy of any and all text messages that they intend to use as a basis for the bond violation and provide that to the defense as quickly as possible. Although I felt that this matter was in a position to proceed to preliminary examination on today's date, I believe that the defense is somewhat hindered by the fact that they don't have the text messages that are allegedly being sent by the defendant in this case. So we will schedule this for a pretrial before Judge Darlene O'Brien on July 29th, 2021 at 1:30.
Thank you.
Thank you, Your Honor.
Thank you, Ms. Nelson. We'll be in touch with you, okay?
Mr. Hill, I'm gonna call you right now.
Thank you.
Copy that.
Good afternoon. The 14B District Court is now in session. My name is Elaine Washington, and I'm the judge that will be presiding over this session. Unfortunately, everyone, I'm still out at preliminary examinations, as you can tell from the change of my background here. What I'm going to do is let the individuals into the courtroom. I understand that we have at least a couple of short or at least one short matter that I'm going to deal with very quickly. And then the rest of you can figure out who's in the space so that when we get over to the 14B court, we can start to actually figure out what's ready to go and what's not ready to go. So we're going to let everyone in. I'll explain the procedure and then I'll go over to the court. Unless you know that something's really short, and I might give my recorder a brief break and try to handle if they're short, meaning I don't have to have a file present with me. I could do that today, but I can't do anything else until I get to the courthouse, the other courthouse. Okay?
I think the Gardner matter could be called.
Yes, I am. I'm aware of
Oh,
that.
thank you. Oh, sorry. Trying to help.
Thank you. All right. I got it. You can run to the bathroom. Good afternoon. The 14B District Court is now in session. I apologize for the delay in getting to you. It was not a delay in me not working. I'm actually out at a different courthouse handling separate matters, and that is why this afternoon's 14B docket is starting a little late. Having said that, what we need to do right now is to identify the people that are in the courtroom, and then after that, I may have you in a brief session where I'm driving to a different courthouse to complete the matters that are actually scheduled for via Zoom. So having said that, I'm going to start with Aristo 4+. Could you please tell us your first and last name so that I can rename you and the attorneys can identify who's in the space? Aristo 4+. What is your first and last name? Aristo 4+, first and last name, please. I'm not seeing anything.
Is that me?
I can't tell who it's talking.
How are we able to tell who you're speaking with? Because I assume my name is just
I'm sorry,
correct.
you broke up for a long time. There is a device that is identified as Aristo 4+. That's who I'm speaking to. I did see that Ms. Monet Williams unmuted herself, so I'm not sure if you're on two separate devices, Ms. Williams.
No, I'm on one device.
Okay, then no, I'm not speaking to you, ma'am. I'm speaking.
Okay, I just wanted to make sure.
All right, thank you. There's someone with the Aristo 4+. I don't think they're connected yet. Let's see. Maybe that's why they're not answering me. And Deputy Garlic is not connected. All right, Aristo 4+ is not connected. And can't answer me. All right. Mr. Simon, what is your client's case number and full name, please?
Your Honor, the name is Shawkeisha Gardner, and the case number is 20S as in Sam 00416SM.
All right, the court will call the case of the State of Michigan versus Shawkeisha Gardner, case number 20S00416.
Good afternoon, Your Honor. Laura Willenberg on behalf of the people.
Your Honor, Joe Simon, I appear on behalf of Ms. Gardner. She is present as well. Ms. Gardner, will you please identify yourself?
Hello. I don't know if you guys can see me. I'm having some problems with the camera.
We can't see you. We can only hear you, but that is fine.
Okay.
All right, today's day and time scheduled for a non-jury trial in this matter.
That's correct, Your Honor. The people are not in a position to proceed, and I did send a nulli pros form over this morning to the clerk's office at 14B.
Thank you. I know that we have received that form. However, I am at a different courthouse and have not had a chance to sign it. I will sign that nulli pros as soon as I return to the courthouse. Ms. Gardner, as has probably been explained to you, and maybe it hasn't been because maybe I don't understand the circumstances regarding this particular nulli pros, but the matter is being nulli pros, and it is likely to not be reauthorized, but they have the ability to reauthorize. So it's without prejudice. Do you understand that, ma'am?
So that means that the case can be picked up again?
It could be, but based on the way it's being nulli pros today, I don't see that happening.
Okay.
Is that correct, Ms. Willenberg?
That's correct, Your Honor.
Thank you. All right. You're all set, Ms. Gardner.
All right, thank you, Your Honor.
Thank you, Your Honor.
Thank you, Mr. Simon. All right. I will allow the attorneys to, so this particular docket is going to be treated like any other court docket, meaning that the prosecutor and the defense will have an opportunity to discuss matters and determine which cases are proceeding to trial and which cases are not proceeding to trial. In the interim time while that is going on, the court will be in a brief recess while we go from one courthouse to the next courthouse. So that will take me about 15 to 20 minutes to do. There's another Galaxy J7 star that I'm going to allow in to try to find out who that person is as well. The Aristo 4+ still has not connected. And the Galaxy J7 is taking forever to join. Galaxy J7 has entered into the court's waiting room twice now, and I've attempted to allow them in with no success. I have that Galaxy J7 in the waiting room 3 times now, and I've attempted to allow them in. I don't know what's happening with Galaxy J7 Star. They have shown up now 4 times. One of them has gone away. Are they in the room? No. Do you want to try and admit? Maybe something won't my admit button. Oh, Galaxy. Okay, they came in. Ma'am, with the Galaxy J7, are you connected? Not connected. Can you? No, you can't do it, can you? Okay. Let me see here.
Hi, my name is Ashanti Mans. I'm connected to my Dell laptop. I'm not sure if it's showing up as a Galaxy.
No, I don't think so. Galaxy J7 has now entered space.
Okay, all right. Just wanted to make sure.
That is not you. I did see you, Miss Mann. She's trying to connect again because I think she can see that we're talking. I don't know what's going on with Arista 4 Plus though.
Your Honor, that is my client at Galaxy. She's trying to get her microphone working.
Thank you very much.
Can you hear me now?
Yes, I can.
Okay, good, good, good. Sorry about that,
Okay,
guys.
can you please tell us your first and last name?
Sure. Tiffany Blaisdell.
Thank you. Tiffany Blaisdell. It's okay. Do you want to go ahead and go without me? Oh, no, I guess it doesn't matter. I'm trying to put up the Arista 4, but I can't get the screen share to work properly. Do we have any short matters before I leave the bench, because I can't get Aristo 4 to go, and I guess that's difficult because you don't know who Aristo 4 is.
Mr. Barnett, please correct me if I'm wrong. I think Mr. Barnett and I have at least one case at the moment that could be called.
Yes, that's correct. We could call the Haynes matter.
All right, thank you. The court will call the case of Ypsilanti Township versus Denise Haynes, case number 09T0920.
Paul Barnett on behalf of the township.
Andrew Banis with and on behalf of Ms. Haynes, who I believe is present. Ms. Haynes, can you state your name, please?
Hello, it's Denise Haynes.
Hello, Ms. Haynes, how are you?
I'm fine, and you?
It's been a day, but I'm okay.
That's good.
All right,
Your Honor, today's the date and time set for a bench trial. At this time, the people are not in a position to proceed.
Defense moves to dismiss, Your Honor.
all right, Ms. Haynes, I'm going to grant your attorney's request to dismiss this matter. The dismissal is without prejudice. What that means is if at some point in time the prosecution is able to proceed, they could reauthorize this matter. Do you
Okay.
understand that?
Yes, Your Honor.
Given the nature of this case, it is not likely, but I just have to inform you of that, okay, ma'am?
Yes,
All right, thank you. Case is dismissed.
thank you.
It is 09T00920. All right, did Aristo 4 Plus connect yet? All right. Unfortunately, we've done all we can do. Well, one more thing that we can try to do.
Judge, we could call the Rihanna Bigham matter if Mr. Banis is agreeable with that.
Ready on that case, Your Honor. Thank you, Paul.
All right, thank you. We're going to put the Aristo 4 Plus in the waiting room and see if that maybe gets their attention. All right. Court will call the case of Ypsilanti Township versus Rihanna Bigham, case number 20W002191.
Paul Barnett on behalf of the township.
Andrew
Hello.
Banis on behalf of Rihanna Bigham. Ms. Bigham, are you present?
Yes.
Hello, Ms. Bigham.
Hi.
Day and time schedule for the bench trial on this matter?
That's correct, Your Honor. At this time, we're not in a position to proceed.
Move to dismiss.
All right, this matter will be dismissed without prejudice. Ms. Bigham, do you understand that if they're able to proceed at a later date, they could reauthorize this matter?
Okay. Okay.
You're all set, ma'am.
All right, thank you.
Thank you. All right, I'm gonna bring Aristo 4 back into the room and see if anything changes. I think they must have joined the room and then went to sleep. All right, here we go. Sir, can you please turn on your audio? Can you put that thing back up to connect your audio? Does anyone recognize that individual as a client?
I believe that as a witness for the people, Your Honor.
All right, thank you. All right, now that we have everybody present and people accounted for, we will go over to the 14B court. And you can talk and discuss things in the interim. All right, sir, with the Aristo 4 Plus, could you please tell us your first and last name?
Is that mine?
No, it's not. Sir, please unmute yourself with the Aristo 4 Plus that just joined us in the white t-shirt. You have to press the.
Yes, ma'am.
Yes.
Smith.
Yes. Can you please tell us your first and last name, sir?
Cornelius Smith.
Cornelius Smith?
Yes, ma'am.
Thank you. I will rename you. Please stay on the line while the prosecutor discusses all matters. The court will resume its session in about 15 minutes or so.
Yes, ma'am.
Thank you. Court's in recess.
Banks have free pens. Marcus by Goldman Sachs has a high-yield savings account with a rate that can earn you 4 times the national average. Then again, free pen. You can find. Being a parent is a lot. All the ups and downs, and the tiny little moments that just knock you off your feet. It's on you to make sure they grow up smart, kind, and that they don't eat whatever that is. There's always a lot going on. We're here to take a few things off your plate. Because staying in the moment is easier when the future's officially taken care of. LegalZoom, let's make it official. Cooking and eating at home more often means food odors get trapped in your home's fabrics and released back into the air, so you smell last night's dinner the next morning. For an easy way to keep your whole home smelling fresh, try Febreze Fabric Refresher. Febrze's water-based formula deeply penetrates fabrics to eliminate trapped food odors as it dries. Spray Febreze Fabric Refresher when you clean up after meals to ensure your entire home smells fresh and clean. Try Febreze Fabric Refresher. Brand power helping you buy better.
Oh, goodness.
All right, the 14B District Court is now back in session on the Zoom environment as well. We do have individuals who are currently in the actual courtroom as well. And as the Zoom environment is aware, the court had to leave from over at the 14A1 Service Center and then appear over here into the courtroom. We are currently here. For the record, I'm signing the noli pros that I indicated earlier I would sign now that I am in my courtroom. I have signed Noli pros in the case of the state of Michigan versus Sequisha Gardner, case number 20S00416. Are we ready on the Fletcher matter? Are we ready on the Fletcher matter? All right, thank you. The court will call the case of Ypsilanti Township versus Michael Fletcher, 21T00261.
Paul Barnett on behalf of the township.
One second, let me turn this volume up so I can see if Mr. Gearing can at least hear you. Mr. Gearing, can you hear Mr. Barnett?
I heard him briefly, and good afternoon, Your Honor. Dan Gearing on behalf of Michael Fletcher, who's to my right.
Thank you.
Today is the date and time set for a bench trial. At this time, we're not in a position to proceed.
Thank you. The prosecutor is unable to proceed.
Mr. Fletcher has a motion to dismiss and understands that would be without prejudice.
Thank you. Given that the prosecution is unable to proceed, the court will grant the defense motion to dismiss. Dismissal is without prejudice, meaning that if the prosecutor is able to proceed at a later date, the court could reauthorize this matter. There appears to be no bond posted in this matter. The case will be closed. You're all set. Thank you. Sorry for the delay today. We were working as fast as we could. Thank you. The court will call the case of Ypsilanti Township versus Gary Mans, case number 21T00209, also known as Ashanti.
Paul Barnett on behalf of the township.
Andrew Vanis with and on behalf of Ms. Mans is present, I believe.
Hello, Ms. Ashanti. How are you?
I'm fine.
All right, can you show us your screen, please?
I seem to have lost it and I can't find
All right, that's okay.
myself on here.
I know you were.
Okay, there it is. I think it started now.
There you go. Thank you.
Today is the date and time set for the bench trial in this case. At this time, the people are not in a position to proceed.
Move to dismiss, Your Honor.
Thank you. The motion to dismiss will be granted. Ms. Mans, the granted dismissal is without prejudice, meaning that if they're able to proceed at a later date, they could reauthorize this. Do you understand that?
Yes.
All
Thank
right.
you, Your Honor.
Thank you. We're all set. This matter is closed.
Okay, bye-bye.
Bye-bye. All right. Monet Williams. Did we lose Miss Monet Williams? She was present, I know. I spoke to her.
Your Honor, I just realized that she's no longer here, so I'm not sure what time she disconnected. I know she was having some logistical problems on where to connect from. So I'm trying to reach her now, if it's okay, if you can give me a moment.
All right, thank you.
I'm expecting her to come back any moment now, Your Honor. I just spoke with her.
Thank you, Mr. Vance. Very good. I don't know why it doesn't work for me.
There she is.
All right. Are we ready to call? Header? All right, thank you. The court will call the case of the state of Michigan versus Monet Williams, case number 18S00678SM.
Laura Willenberg on behalf of the people.
Andrew Vanis with and on behalf of Ms. Williams, who is present.
Hello, Ms. Williams.
Hi.
All right, today is the day and time scheduled for a non-jury trial in this matter.
That's correct, Your Honor. The people are not in a position to proceed.
Move to dismiss.
Thank you. This matter will be dismissed without prejudice, Ms. Williams. I think you've been on the line at least for part of the time, and you heard me say to several other people that the dismissal means that if the prosecutor is able to proceed at a later date, they could reauthorize this matter. Okay? Is that a yes, ma'am?
Yes. Yes.
All right.
Can you hear me?
I can. Yes, I can.
Awesome.
All right. You are all set. Thank you. This matter is dismissed.
Is there a time frame on when they're able to
I can give you a call after court today and explain that to you, Ms. Williams, if that's okay.
All right. Ms. Williams, did you hear your attorney?
Yes.
All right. Thank you. You're all set, ma'am. Have a good day. All right. Are we ready to proceed on the Blaisdell matter?
Yes, Your Honor.
All right. Mr. Banis, for your information and for purposes of making an informed decision today, I don't know if you have received a copy of the bond violation report.
I do have a copy of that report, and I've reviewed it with my client, Your Honor.
Thank you. And I presume that you've received it as well, Ms. Willenberg.
Yes, Your Honor, I have.
All right, thank you. All right. Are there any opening arguments?
Your Honor, for the record, there was an offer in this matter to plead to an AV under prosecutors deferred with an agreement to do an alcohol assessment and to follow those suggestions following that assessment, it is my understanding that Ms. Blaisdell would like to proceed to trial on this matter. And if that is the case, the people will waive opening on this matter.
That's correct, Your Honor. Ms. Blaisdell asserts her innocence in this case and absolutely wants to proceed to trial, but I do always appreciate an offer, and I will also waive opening.
Thank you, Ms. Blaisdell. As you just heard, the prosecutor has indicated that if you were to admit, or I'm sorry, if you were to plead guilty to the assault and battery, they would place you on their deferred program. If you completed the terms of probation, this would not be on your record. You understand that, ma'am?
I do understand that, and I did decline.
You are rejecting that offer. Is that correct?
Correct, correct.
Right. Thank you. All right, you may, and both of you have waived opening arguments. With that being said, you may present your first witness. Ms. Willenberg.
Thank you, Your Honor. The people call Mr. Cornelius Smith.
Yes.
All right,
I'm
Mr.
here.
Smith, please raise your right hand to be sworn. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, thank you. You may proceed, Ms. Willenberg.
Thank you, Your Honor. Good afternoon, Mr. Smith. Can you please state and spell your name for the record?
Cornelius Smith, Cornelious, Cornelius, last name Smith, Smith.
Thank you, Mr. Smith. Are you familiar with Ms. Tiffany Blaisdell?
Yes.
How do you know her?
Well, she's someone I just, rent a room from, for month to month. So
Okay.
basically, she's like my landlord. Roommate / roommate landlord.
So she lived with you, correct?
Yeah, I live with her. But
Okay.
I had just removed myself. So.
And do you
Right,
see,
end of what you just said, sir? You just did what?
I just removed myself from the address.
Okay.
do you see her present here in the virtual courtroom today?
Not for sure. I haven't looked on the camera yet.
Okay. Do you have a way that you can look at the participants and scroll through them?
Yes.
And if you can identify her by what she's wearing?
I see her sitting in a chair.
Okay. And what is she wearing?
She's wearing a shirt with different detail on it. Well, I don't know exactly what it is because it's kind of dark in the dark room. She got her hair laid down. So.
Okay, Your Honor.
It's kind of hard to identify the t-shirt. The sleeve. I know she's wearing a long sleeve shirt.
We'll stipulate to the identification, Ms. Willenberg, in Your Honor.
Thank you, Mr. Garner. Mr. Smith, do you recall where you were on May 22nd of this year, 2021?
Yes, I was. I just left. I just pulled up, came in the house, and then when I came up, because we came from shopping, then I went to lay down, and for a second, because I was very tired, ripping and running around. So when I got up,
Mr. Smith,
go ahead.
Where is the house that you were living at? What's the address?
The address, I don't know. 640 Warden.
Okay, is that in Ypsilanti Township?
Ypsilanti, Michigan, yes.
Okay, is that in Washtenaw County?
Yes, ma'am, Washtenaw County.
Okay, and that's the location where you lived with Ms. Blaisdell, is that correct?
Yes, ma'am.
Did anyone else live there?
Yes, Tiffany Moore, for just, just for a split second.
Who is Tiffany Moore?
This is my girlfriend.
Okay. And you said you arrived home and you took a nap. What happened after you took a nap?
Well, I woke up and came in the living room, and I seen Tiffany on the couch, very heavy intoxicated,
Mr. Smith,
upset about.
since there are two Tiffany's
Go ahead.
involved, will you clarify which Tiffany you saw
Yeah.
on the couch? Ms.
Yes,
And
ma'am.
Your Honor, just, I'm sorry to interrupt. I'm going to object to, based on speculation or in addition to medical conclusion of her state of mind. I mean, if he has some personal knowledge of any consumption of alcohol, certainly Ms. William-Brink could address that. So I'm objecting to his statement about her level of intoxication.
Ms. Willenberg.
Your Honor, I believe he can testify to what he observed about her behavior. I think we all have an idea of what someone who is intoxicated might act like, so he can testify to his personal knowledge of her behaviors and how she was acting.
Thank you. Based on your response, I will allow you to ask him questions to build a foundation for him making the statement that she was very heavily intoxicated.
Okay. So, Mr. Smith, you observed Ms. Blaisdell in the living room?
Yes, when I arrived in the living room, Miss Tiffany Blaisdell was sitting on the love seat couch near where half a pint of vodka, apple Amsterdam apple vodka, and she was loud and saying being obnoxious, and she was upset about the neighbors across the street kicking her out because she was disturbing a kid's birthday party. And so she took it out on me and my girlfriend. So I was going in the kitchen trying to walk away, ignore her. So when I went in the kitchen, she kept it up. Go ahead.
Mr. Smith,
Yes,
I'm
ma'am.
just gonna slow you down a bit. I'm gonna ask you one question at a time. So you observed her drinking alcohol, is that right?
Correct.
Okay, and what do you mean when you say she was loud and obnoxious? What was she acting like?
Well, she was very upset because the neighbors kicked her out, out the house across the street. And she was
Objection,
talking-
hearsay. I don't think it sounds like he wasn't there, so.
Ms. Willenberg?
I will rephrase the question. Mr. Smith, what was Ms. Blaisdell saying to you?
She basically said she was upset that how could they kick me out and I wasn't doing nothing, I was trying, say hello and stuff like that. And then she turned around, looked at me and said, "You going to pay your rent and you're going to pay me an extra $400 and all this stuff." So she was taking it out on me, whatever happened, But at the same time, that's what's coming out of her mouth. So it came out of her mouth. So I can't, control what, how she was acting. All I can do is, try to, walk away from the situation. So I can understand everything what you were talking about. Only thing I heard, she was telling me, I'm gonna pay her rent and I owe her, or I'm gonna get out, I'm a bum or stuff like that. And I'm like, she going off on me. So I don't know. I just know she was just going straight. She was talking and intoxicated, because I know she was intoxicated because my mama drank. So I know when a person intoxicated. I see the bottle right in front of me. That's the reason why I called the 911. I got hit in the back when I was talking to the dispatch.
Mr. Smith? Okay,
Yes,
so
ma'am.
what happened after you had that conversation in the living room? What did you do next?
I told her, I said, I paid you already and you trying to collect another extra $400. What extra $400? And she looked at me, and that's when it really went left field. She was like, "Oh, what extra $400? Oh, okay, I bet you you want to get in here tonight," because she was on trying to change the locks. So she was being conniving, evil, like she was being evil. So I don't know how to explain it. It's just like she was being very, very vindictive. So I cannot, stop
Smith,
her, acting out like that.
Where was she sitting on the couch? Where was Ms. Blaisdell?
She was sitting on the couch first, but when I told her, I said I paid her already, and I said you owe me one more month. before I give you another 400. So she got up out of her chair and started hollering in my face. I walked away. And then I said, she was like, okay, we'll bet you this. And I said, you know what? I said, keep this up. I mean, I had to call the police again involved. And she's like, you know, call the police. I call the police on you and telling you assaulted me. I was like, come on, Tiffany, don't do that. And she was like, well, I will. You know what I'm saying? And she was basically telling me she'll set me up. So I'm looking at her like, chill out. And she got in my face and started spitting while she's talking because she intoxicated. That's the only reason why I know, because I can smell the earth of the liquor off her breath.
Okay.
So I had to call 911, and when I was dialing 911, and she steady again hollering, and then when she heard the officer pick up and said something to me, she hit me, and then I was like, well, she just hit me while I'm talking to you. They got me on the recording when I was saying that.
Mr. Smith, so where were you when you were calling 911?
In the kitchen, because I walked out the living room into the kitchen.
So were you walking away from Ms. Blaisdell?
Yes, ma'am. I was walking away. That's what I was calling. And then when she hit me, I walked fast out the back door and stayed in the backyard till the police came.
Okay.
And stayed on the phone.
Where did you feel that hit?
Right on my left side, upper shoulder, upper left back.
Okay. So you were facing away from her when she hit you?
Yes, I was facing away towards in the kitchen towards the hallway. It's like it's another hallway, like going towards the back entrance in the backyard. So I was on the phone, I had the phone in my right hand, talking to the dispatch officer while she hit me at the same time when the officer was talking to her.
Okay. What did that hit feel like? Was it hard? Was it?
I thought she hit me with a glass jar, like a coffee mug or something. The way she hit me, I didn't know why she would hit me, because I didn't know, because she had got into some type of ramps before, and I had, walked away and walked out the house and left and let her calm down, but she wouldn't let me leave at that time. So I knew I had to do something, let the police get involved. So that's the reason why. And I never really called the police. I really never called police on people. But I had no choice at this moment, because I cannot afford, get solving something that I cannot fix. The police got to take care of it. I can't do nothing about it.
Okay, so after you felt that hit, what did you do next?
I walked out the house real fast. I paced myself out the house real fast and stayed on the phone until the police arrived. And the police stayed on the phone with me and telling me what she's doing and where she is at. And I said, yes, she's still in the house. She haven't came out. And so the police arrived, and then I jumped over the gate and went and talked to the officer, and left my back up. And the police went in there and talked to Tiffany and talked to Blaisdell. And then they came out and then they arrested her, because, 9 out of 10, ain't no another woman don't lie on another woman. They both the same name. And when it comes to women, it's women power. And I'm
okay,
just
Mr.
being
Smith,
honest.
Mr. Smith. Okay, thank you. That's all the questions I have for you. Now Mr. Banis might have some questions for you.
No problem.
All right, your witness, Mr. Banis.
Thank you, Your Honor. Good afternoon, Mr. Smith. I'm Andrew Banis. I'm Ms. Blaisdell's lawyer, so I'm going to ask you some questions. Okay, so I listened closely to your testimony. And you said that you rented a room from Ms. Blaisdell, and that you live with her. So was that, can you describe the apartment for us? Did you have your own separate room?
Yes, we did have our own separate rooms, 3 bedrooms.
And then now the other Tiffany Moore, your girlfriend, did you and Tiffany Moore live in one room together?
Yes, ma'am.
Okay, so you got you and Tiffany Moore in one room, and then Ms. Blaisdell in another room. Is that correct? Okay.
Yes, but she don't sleep in her room. She sleeps in the living room.
Okay, I appreciate you trying to answer. I'm going to ask you some very specific questions. Ms. Williamburn can always follow up with some additional questions. Okay, so we're talking about May 22nd, 2021. Is that how long had you lived there at that point? Approximately.
By that time, probably almost 2 months, going on almost 2 months, 5 months and some going on 2 months.
And this was in actuality a temporary living situation, right? Ms. Blaisdell was
Correct.
helping you and correct? Okay. And then you were supposed to be out of the apartment by June 1st of this year, is that correct?
No, July 15th.
Okay. Well, you actually left the apartment on July 15th, right?
Yeah, I've been left.
On July 15th?
Correct.
And you?
July 15th, no. I left a long time ago, June 15th.
Okay, June 15th, thank you. And you said before you removed yourself from that address, quote, remove myself, quote, on address. Actually, you were actually required to move out, right?
No, July 15th, but I didn't remove myself early from the date that we had agreed upon.
Right. So you're saying you and Ms. Blaisdell agreed that you would move out on June 15th, 2021?
No, I said July 15th, not June 15th. I left in June. In June, and we supposed to leave in July 15th. I left in June.
Got it.
An agreement was July 15th.
Okay, thank you. I promise you I wasn't trying to trip you up on the dates. I just want to make sure I got it here. So, okay. And then you said that Tiffany Moore lived there for, I think you said a split second. Did you mean by that she lived there only a short period of time? Or was she there the whole time you lived there?
A split second, because she wasn't there the whole time.
Did Tiffany Moore live with you at this address at 640 Wharton the whole time you lived there?
No, sir.
Okay. Okay, so now, so on May 22nd, there was an argument between you and Ms. Blaisdell?
It was a communication dispute about the rent.
Okay. And so you said that she brought up that you'd owed her some additional money. Are you saying that you had already paid her everything that was due?
Yes. So I gave her additional money ahead of time, and she go spend her money and then come back and turn around and say I haven't gave her nothing, which is insane. So I even took her. Yeah, I even took her out, bought toilet tissue, bought soap, stuff like that, and then she look at me and say, "What did I do?" And I say, "All right, I guess I ain't do nothing for you then, if that's what you say."
Okay, so the argument was that night it was more about just money though, right? It was more about the total living situation.
No, it was about she was upset about the neighbor kicking her out the party, the kids' party across the street. So she took it out on me and Tiffany. So that's what happened.
Okay. Well, tell me if you disagree with this. Actually, there was kind of an ongoing problem with this living arrangement, right? And that was all part of this discussion or dispute or argument on May 22nd. For example, you and Tiffany Moore argued a lot and fought a lot, correct?
No.
You never had an argument or physical or verbal with Tiffany Moore while you two were living there?
Any couples have a disagreement.
Okay.
I don't know not one human being on this earth don't even argue with their sister, brother, auntie, or they even friend. So anybody will have some type of dispute about something.
And actually, neighbors were complaining about this, or about you and Ms. Moore, weren't they?
I'm not notified about nothing, any of them type of activity.
You're not aware of any neighbor complaining about you and Tiffany Moore?
No, sir.
Okay. And in fact, you and Tiffany Moore were drinking quite a bit and smoking large quantities of marijuana in Ms. Blaisdell's apartment, right?
Can I ask you one question?
No,
What
you
does that
cannot,
have to
sir.
do-
You cannot, sir. I'm asking you about
That don't have nothing to do with the case. It's just going off the case. I got hit. When I get hit, I got hit. Ain't got nothing to do with about my criminal background, about if I'm black or white. If I get hit, is it right? Is she wrong? She hit me. That's just it. Ain't about is you trying to find what is this on guilty or not. If you don't want to make her guilty or not, is it okay she can hit me? It's okay. Y'all want her to hit me? It's okay. Is this okay? She can get drunk, intoxicated, and hit people. She need more help. I'm not a criminal. I'm the victim. I'm not going to sit up here and let people just victimize me and try to criminalize me over something that's not right. That don't got nothing to do with the case.
Mr. Smith.
It doesn't.
Mr. Smith.
Yes,
All right.
Your Honor.
So, Mr. Smith, you're on the witness stand. The defense at this point has an opportunity to ask you questions, and you have to answer those questions, okay? And then
Yes, Your
I
Honor.
decide what happened and what didn't happen. That's where we are with this, okay? So just answer his questions, please.
Yes, Your Honor.
Thank you.
So on May 22nd, 21st, 2021, excuse me, you testified Ms. Blaisdell hit you. And before that, there was this argument or dispute. That's what I was trying to get at. And in fact, during that discussion, dispute, or argument, you were actually screaming at her and up in her face, were you not?
No.
Would you say, Mr. Smith, you have a bad temper?
No.
Okay. And the dispute or discussion or argument on May 22nd, it was, it actually also include problems that were leading up to that, like you and Ms. Tiffany Moore smoking large quantities of marijuana, drinking lots of alcohol, complaints from the neighbors, and arguments. Is that not true?
That's not true.
There's an objection on the floor.
I believe this has already been asked and answered.
Well, I tried to ask him about well, I'll move on, Your Honor.
Thank you.
I'm going to be calling Ms. Blaisdell as a witness anyway. Okay, so.
I have a medical license for marijuana, so.
Okay, I'm sorry, Mr. Smith. Just give me one second, Mr. Smith. I'm trying to see if I have any more questions for you. I apologize for interrupting you there.
No problem.
So you no longer live at the Warden Street address, right?
No, sir.
And when you left the apartment, did you take any of Ms. Blaisdell's property?
No, sir.
Okay. Your Honor, I have no further questions for Mr. Smith.
Thank you. Anything follow up, Ms. Willenbrain?
I have no additional questions for Mr. Smith.
Thank you. May this witness be excused?
Yes, Your Honor.
All right, Mr. Smith, thank you for testifying today. You are excused from the witness stand. You can choose to stay on the line if you want to. That is completely up to you. You are the complaining witness in this case, and you have a right to remain in the courtroom, sir. Okay?
All right.
All right, thank you, sir. Any further witnesses, Ms. Willenbrain?
No, Your Honor, the people were.
All right, thank you. Mr. Banish, your witness.
Thank you, Your Honor. I'm calling Tiffany Blaisdell as a witness in her defense, and she's aware, Your Honor, she has a constitutional right not to testify in her defense, and that she's presumed innocent. She's waiving that right, and Ms. Blaisdell, can you confirm that you understand you're not required to testify?
I do understand, and I'm willing to testify.
All right, so you're choosing to waive that right and testify today, Ms. Blaisdell. All right, thank you. Please raise your right hand to be sworn, Ms. Blaisdell. Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
So help me God, yes, I do.
Thank you. You may proceed, Mr. Banish.
Thank you, Your Honor. Good afternoon, Ms. Blaisdell.
Good afternoon.
So, okay, so let's start with the living arrangement with Mr. Smith and Ms. Moore. Why don't you describe that? And I don't mean who slept where, we can get into that. I mean, how long were they supposed to stay there?
They were supposed to be there until June 1st. No July 18th, no July 15th, June 1st was the date they agreed upon, because they didn't have any further monies to pay any additional rent. And they still had not fulfilled May's rent. And that's why that was brought up in a discussion on May 22nd.
Okay, and Ms. Blaisdell and everyone else, the sound is not great on my computer today for some reason, so I'm leaning in a lot, and it's only so I can.
I actually think that it's her. I think I could hear Mr. Smith very well. I need Ms. Blaisdell to speak up or sit forward, or both.
Okay, I'll bring it closer to me. Is this better?
Yes, it is.
Okay, cool. All right, I'm sorry.
Okay. So tell us what, now on May 22nd, 2021, you have any kind of discussion with Mr. Smith?
There was discussion of rent. The man has a temper, regardless. And I mean, of course, you know, I've witnessed it. The discussion was they have to be gone by June 1st. I'd fed up with all the shenanigans, the fighting, you know, the police being called to my home, and they had to go. And of course, he was arguing right back in my face. I felt intimidated, threatened, and I pushed him, which I've admitted to doing.
Okay, so, okay, thank you. So that let's back up and I'll break that down a bit. So you said shenanigans. What do you mean by that?
Pot smoking, the arguing, the
Now, when you say arguing, I'm sorry, are you talking about between who and who?
Tiffany Moore and Cornelius Smith.
Okay. Now, did they have their own room together or were they separate?
They were together in one room.
Okay. And were there any complaints about that? About the shenanigans?
Oh, yes. I had complaints from the neighbors because the windows are always open in that bedroom, that they were in fighting constantly. And I was asked to tell them to close the windows. But again, they just continued, as if I was invisible and that my neighbors meant nothing. And I warned them that they would call the police, in which in fact they did.
I'm sorry, you warned them what?
I warned them to keep the windows closed, and they kept them open and continued arguing. And one time the police did come, not once, but twice.
All right, so how many times have you called the police about them?
I had to call them the second time for the police to come because they were both screaming and yelling at me, threatening me. And so when the police came in the second time, one of the deputies I discussed with you was here, almost shot Mr. Smith because he rushed towards the deputy.
Are you talking about May 22nd or an earlier date?
No, that was, no, not May 22nd, an earlier date. But this is
Okay.
just an example of the things that I have to deal with,
Okay.
the living arrangements.
So, okay, 1 second. So on May 22nd, really was this dispute or argument with Mr. Smith about more than just the money that he owed you?
Not necessarily, it's just the fact that I need to make it clear that they needed to be out. And that I was just sick and tired of being sick and tired of the living arrangement. And that I
Okay.
could do only as much as I could for favors, while they waited on their Section 8. And I couldn't handle it anymore because I didn't want to be evicted because of my neighbors complaining or the police coming and the township getting involved, which clearly they have.
And I mean, did you drink any alcohol that day?
I did have some alcohol, correct? Yep.
Okay.
He was accurate with the apple drink.
Okay.
That was
And
yesterday.
now you said Mr. Smith has a temper. Is that from personal experience?
Yes, absolutely. I can give you one example where he's screaming in my face. My dog jumps on him, just like in a playful manner. He smacks her so hard on the top of her head that she yelps and takes off. And he acted like it was nothing. And he's been in my face screaming numerous times before. He's an emotional man. When he doesn't get his way, then, he takes things out when him and Tiffany Moore are fighting. I'm not somebody's punching bag. And I'm definitely not a relationship counselor.
Now, did you say before that you pushed him?
I did. I got him out of my
Okay,
face.
I'll ask you questions about that. And so are you talking about May 22nd, the alleged
Correct.
incident date? Okay.
Correct.
So tell the judge, tell us what happened that day that led to this push. And then I'll ask you more about some other
It was
things.
back and forth with the screaming, him in my face. He's a very intimidating man. I'm intimidated by him. I've witnessed before, for the record, that he was actually had Tiffany Moore in a chokehold. And I almost came after him actually with a mag light to break her away from him. And he challenged me. She said, please don't. And so I knew, if he would put his hands on the woman that he loves, he was going to put his hands on me. So I shoved him away.
Okay, hold on. This mag light incident, you're saying that was May 22nd or earlier?
No, that was a time before, but that's
Okay.
what led me because I feared because of how he was and what I've seen in the past, why I reacted the way I did on the 22nd of May.
Okay, got it. So now back to May 22nd. So did you say how was he? So at one point, were the two of you in the kitchen?
The house is open. So the kitchen and the living room are just an open, big space. So
Okay.
yeah, it was it's not like you can go from one room to another. It's all open.
Well, let's do it this way. Think about the moment you pushed him, okay? And then go back, say 5 minutes. And if we need to go back further, I'll ask you about that. Tell us about those 5 minutes before you pushed him.
It was about the money. And I brought it up. I mean, it'd been eating at me, it bugged me, and perhaps, alcohol made me trigger a little more anger, but maybe not. But I just, with these two going back and forth, I'd had enough, and I wanted the rest of my money for May, which they did not pay. Actually, I was lending them money in May to help them with things. And he's screaming back and forth. You can't understand half the time when he's so angry, what he's saying, the spitting.
Okay, so he's saying things to you during those 5 minutes?
Yep.
And what level of voice? Whispering to shouting, screaming? What's his attitude?
Bitch,
I'm sorry?
this, bitch that. Screaming in my face. Bitch this, bitch that. I don't know you shit. I mean, those are just his words. Okay, and I apologize for swearing.
Is he facing you at that time or away from you?
Yes, sir. Yes, facing me, face to face.
Okay, how close?
Very
Well,
close.
first of all, so since I'm going to ask you about how close he was, how tall are you?
I am 5'1".
Okay, and he's lived at your place, so what would you say his height is?
Maybe 5'10", 5'11".
Do you know how much he weighs?
I don't know. He's a lot of muscle. That's all I know.
Why do you say he's a lot of muscle?
Because he had done time in prison, and that's where he built.
Well,
all his muscle.
okay, I'm not asking you about
Okay,
any of
sorry,
that. I'm just asking you what personal knowledge you have about why you say he's a lot of muscle. So anything
Because
you have you seen him with his shirt off?
Yes. Yes.
Okay. So is he muscular?
Very muscular.
Okay. Okay, so now so back to this, you said he was screaming in your face. How close to you was he when he was doing that?
To the point where spit was actually hitting my face. I'm screaming. And this is not the first time that he's reacted like this in my face and gotten that close.
Okay, so on this particular date and time, well, you say so close that the spit is coming out of his mouth or saliva into your face. So are you saying like a couple inches or what?
I'd say about maybe 10 inches.
Okay, so how did you feel when all those things were happening during those moments before you pushed him?
Very threatened and scared.
And is that because of things that happened that day and the past, or what?
Because of things that I've seen in the past, what he's capable of and what he's done.
So you said, what other emotions were you feeling, if any?
Just scared, terrified. I'm shaking, like inside, trembling. I mean, all I can do is just react to protect myself.
Okay.
Because I've seen
So,
he's damaged property in the house because of these temper tantrums.
what properties he damaged in your house?
He knocked off the thermostat and the wall. He's thrown grape or cherry juice all over the walls. When he's threw a container, he's thrown a set of keys. And this is all fights just in temper tantrums, anger, pure anger. And they had to replace the thermostat, which is true, and they did. But still, it shouldn't have to come to that.
Okay. And so while you're feeling all these emotions, did you put your hands on Mr. Smith in any way?
Just to push him away from me.
Okay.
That is
Did he fall down?
No. You can't knock that brick wall down.
Okay. So you push him away for what reason again?
Because he was in my face. He was in my face spitting.
My sound really is not too good.
I'm sorry. I'm trying to speak a little louder
it's
for you.
It's not just you. Go ahead.
Because he was in my face and he was yelling and screaming.
Okay.
So that's in my personal space. I'm going to push you away.
And then did he, around those same moments or minutes, did he put his hands on you or not? I don't think there's any.
No, he did not. No, he did not.
Yeah, I don't think there's any dispute about that. So
No.
And then you heard his testimony today?
I did.
He said he then left the apartment. Is that basically how it ended?
He stormed through the back, but that's when he grabbed the phone to call 911. That's all he was doing. He was secretly calling 911 out in the back. I couldn't hear what was being said. I don't know what was addressed because it was on the side of the van when the police showed up. So I had no say what he was saying, what was being fabricated. But yes, he went out the back and called 911.
Okay. And at some point after that, the police arrived?
That's correct.
And one of the deputies spoke with you?
That is correct.
All right. And you were honest when you spoke with the deputies?
100%.
And did you tell the deputies that, one second here. Did you tell the deputy when they asked you that? No, I'm sorry. They were there that same day or night, right?
Mm-hmm.
Okay.
The same day.
And did you tell them that there was an argument about the living arrangements?
Correct.
And did you tell them that he had been in your face, so you pushed him away?
Correct.
So you were honest then.
Mm-hmm.
And did you ever hit him in the back while he was walking away from you?
Why would I hit him in the back when he's in my face? No, that would make no sense.
So is that it? No.
Away from me. I'm not going to hit you in the back, and I'm not taking a chance. No, I did not. Absolutely not.
I just want to make sure you have an opportunity to answer that question. Okay. Okay, now, so I'm sorry, so what time, so do you know what day they, first of all, is this a home or an apartment?
This is a home.
Okay,
This
now,
is my parents' home, which I sold to a friend.
your parents' home,
Mhm.
you sold to a friend, so you have a landlord?
Correct. Yeah, I rent it from him.
Got it. So is there a lease?
Yes, there is. We are month to month right now.
And who are the tenants under that lease agreement?
Myself.
Anyone else?
No.
Okay. So do you know what time, or I'm sorry, not what time, what day Mr. Smith and Ms. Moore vacated the home?
I'm going to assume because the
Well, don't
landlord told
assume,
me-
I'm just asking if you know.
Okay. Well, the landlord told me he gave them until the 15th of June to be
Objections
gone.
with hearsay.
Okay.
No response, Your Honor.
But this is
I
the
will
landlord, my
rephrase.
landlord.
Okay,
Ms.
hold on.
Blaisdell, please stop testifying until we address the objection that's on the record.
I have no response, Your Honor. I'll make pointed questions going forward.
Thank you.
Okay, so now, during this case, on what day, first of all, are you back living at your home?
I finally got back into my home on July 1st.
July 1st, okay. And what was the condition of your residence when you got back there?
I had to have an attorney get me back in my home because the landlord.
Objection, relevance.
Mr. Banish.
I'll rephrase the question, Your Honor. Was anything missing from your home?
Absolutely.
What was missing?
Objection. Still wondering why this is relevant to the May 22nd incident.
Banish.
I'll move on, Your Honor.
Thank you.
Okay. I have no other questions for Ms. Blaisdell at this time, but there may be some redirect.
Thank you. Ms. Willenberg.
Thank you. Good afternoon, Ms. Blaisdell.
Hello.
You mentioned an altercation with Mr. Smith and your dog. Did you call the police at that time?
No, I didn't because they tried to, get away
Okay.
from me.
Just yes or no, Ms. Blaisdell?
No, I did not.
And you mentioned a time when allegedly Mr. Smith and his girlfriend were arguing and it got physical. Did you call the police then?
I did one time, yes.
One time you did. And on the May 22nd date, you said that you had been drinking, right?
That is correct.
And you had been drinking quite a bit. Is that correct?
That is not correct. I never agreed to that. No.
Okay. Were you?
There was only a half a bottle gone.
Were you able to speak clearly at that time?
I'm pretty certain I was, yes. Just
You're
as clear
pretty
as I am
certain, or you
right
know?
now. It was only a half a pint. I mean, it wasn't like it was like 5 bottles later. No. It was a half a pint.
A half a pint of what, Ms. Blaisdell?
It was like an apple vodka.
Okay. And you said that you were argumentative with Mr. Smith. Is that correct?
Yes.
And you put your hands on him, right?
I pushed him away from me.
Okay. And you didn't have permission to push him, right?
He didn't have permission to be in my face.
But you did not have permission to push him, right?
Was I supposed to ask to get somebody out of my face when I feel threatened?
So you stated that after you pushed him, he left the residence. Is that correct?
He went in the back and started to call 911.
Okay. That's all the questions I have, Your Honor.
I have some questions. Ms. Blaisdell.
Yes, ma'am.
So you said that you started having the discussion with him regarding the fact that they needed to be out of the home, correct?
Correct. There had been an ongoing discussion prior to even the 22nd of May.
All right. At what point did the conversation become heated?
It has become heated multiple times in the past as well.
Not talking about the past, Ms. Blaisdell.
that
I'm
day,
asking you simply about today's date, and please don't speak over me.
Okay, I'm sorry. Probably within the first few sentences.
All right. What did he say that was the first heated thing, Ms. Blaisdell?
Calling me out of my name.
And what did he say? Total
I'm
sentence.
not giving you any more. This, you got what you're getting, and it was just in anger, just spewing constantly. Yeah, calling me names, and he flew right off the handle, Your Honor.
So at any point in time, did you discuss with him the neighbors being upset about the fact that you were removed from the party?
They have been aware of that multiple times. I have verbally told them.
I don't think you heard my question because you didn't answer that. My question was, at any point in time, did you explain to him that you had been kicked out of a children's birthday party at the neighbor's house on that date?
I did not.
Okay.
It was not a children's birthday party.
Okay. Was there a party next door?
There was a party across the street, correct?
Okay. And were you kicked out of that event, ma'am?
I was not kicked out. I was just asked to only be family members. So I said, okay. And I came back laughing about it in the house. There was no anger.
Okay. Now you said that the conversation immediately went to anger from him. Is that correct?
Correct. That is correct.
And what happened next after he called you the bitch and said he wasn't giving you any more money? What was the next?
Then I was calling a bum. You got to go. I want you guys out, and that's when the scream match just continued, the back and forth, back and forth. I mean, I can't remember everything. I was quite upset. I mean, I can't give you detail, but I can confirm, where it was going to lead to and what it has led to today.
All right, thank you. No further questions.
Your Honor, I have just some follow-up direct after Ms. Willenbring's questions, if I may do that now.
Yes, sorry, I apologize. Jumped ahead.
I'm going to move to get on the
Oh, no. All right, that's fine. No problem. Okay, so Ms. Blaisdell, Ms. Willenbring asked you if you had drinking, and you said you had. And then I asked you a bunch of questions about what happened. The judge asked you some questions. How clear is your memory about that day?
That's relatively clear.
Okay. Now, Ms. Willenbring was asking you about police reports, how many times you called the police. So when you got back to your apartment after they had vacated, did you call the police then?
Yes, I did.
And why'd you do that?
Because they had stolen my property.
What property are you missing?
I am missing a 43-inch flat screen TV, a mini refrigerator I allowed them to use, 3 mountain bikes, about 60 DVDs, and I'm still finding more and more stuff missing. But that was the lump sum of the most expensive items that were missing once they vacated.
Are you missing any documents?
I don't know yet.
Objection. I still don't see the relevance of this that happened after this May 22nd date.
Mr. Manis, relevance, please.
The relevance is that there's been testimony that this couple have caused Ms. Blaisdell a lot of problems. And Ms. Willenbring had asked her, as if it was relevant, about how many times or whether she called the police on this incident or that incident. So I think it's relevant that she did call, as she testified, she had to call the police again regarding this incident. Even though it's after the date, it's still part of the global relationship. And I think also there was testimony that the argument that day was much more about just a couple $100 that was missing.
For the record, I do not find the testimony of what happened after this event to be relevant. We'll hear about whether or not there was an assault and battery by Ms. Blaisdell on that particular date.
Okay, thank you, Your Honor. I have no other questions.
Thank you. Any, well, that was the end of that.
And I have no other witnesses, Your Honor.
Thank you. Ms. Willenbring, do you have any rebuttal witnesses?
No rebuttal witnesses, Your Honor.
Are we ready for closing arguments?
Yes, Your Honor, may I just have a moment?
Yes, you may.
Thank you. Okay, I'm ready, Your Honor.
All right, you may proceed.
Thank you. Your Honor, Mr. Smith testified to waking up from a nap at the house that he was living at and walking into the living room where he found Ms. Blaisdell. He testified that he saw her drinking alcohol and that she was being loud and obnoxious, and that from his experience, he believed that she had been drinking and that she was acting in a way consistent with someone who had been drinking a lot. Mr. Smith stated that she started talking about how she had been kicked out of a party across the street. She was upset, she was getting loud, and the two got into some kind of argument. Mr. Smith testified that he was trying to defuse the situation, stated that he was going to call the police because he didn't think that he could manage. And when he turned around, he testified that Ms. Blaisdell hit him in the back. And Mr. Smith then exited the residence. I think it's undisputed that Ms. Blaisdell had been drinking that day, and that things might not be as clear to her as they were to Mr. Smith. But Mr. Smith did testify that he felt a hit on his back and then went to the backyard to defuse the situation. Given that testimony from Mr. Smith, I ask you to find Ms. Blaisdell guilty of assault and battery. That's all I have.
Thank you. Mr. Banis.
Thank you, Your Honor. Ms. Blaisdell testified and that she was honest with the police. Her testimony today is consistent with that. She told the deputy that same day that he was in her face screaming. There was an argument about the living arrangements, and that she pushed him. She testified how she felt about that, and she had examples of why she was feeling emotions of feeling threatened and scared. So I don't believe a push in that circumstance meets the elements of an assault or assault and battery. But of course, even if you feel it does, I believe we've established that there is self-defense going here. And once there's evidence of self-defense, the state, of course, has the burden beyond a reasonable doubt of proving it wasn't self-defense. So that leads to the question, perhaps, of do you believe that Mr. Smith, that she hit him in the back, a muscular man, many inches taller than her, but muscular man, hit by a 5'2" woman in the back with her hand, is, I believe, his testimony, that it felt like a jar. I'm sorry, Your Honor, I don't find that credible. So there's that. And I don't believe they've proven beyond a reasonable doubt that each and every element of this alleged assault and battery. As I said, she testified what happened, and she explained to you, she told the same thing to the police. Now, I think it's clear from the testimony that there was, and again, this goes to self-defense and how she was feeling that day and how he was probably feeling that day, is that there were a lot of problems here. This was a temporary living arrangement. It wasn't working out. She testified, I believe, that there were Mr. Smith and his girlfriend were arguing, fighting. There was the issue with the window had to be closed. The neighbors were complaining. There's an issue of marijuana, but I think that line of questioning, I just moved on beyond that. And all of that goes to how she was feeling that day while he was, as she testified, screaming in his face. And she also explained why she, incidents where he has a bad temper and she had to call the police several times. So, Your Honor, I hope you will find her not guilty of this crime. I don't believe the state has shown beyond a reasonable doubt each and every element. And I also believe that we've established that this push, which she has not shied away from at any point, was done in self-defense. Thank you.
Thank you. Anything further, Ms. Willenbray?
Nothing further from the people, Your Honor.
Thank you. The court has listened to the testimony of Mr. Cornelius Smith as well as Ms. Tiffany Blaisdell. In listening to the testimony, a part of what the court has to determine is credibility and who the court is going to believe in any given circumstance and situation. A part of what this court oftentimes looks for is the details of an event in order to determine who is being truthful about it and who is not being truthful about that particular incident. In this case, Ms. Blaisdell indicates that she pushed Mr. Smith in self-defense, and the self-defense has been asserted, so the court has to address it. The truth of the matter is, I don't believe that it happened in that way, shape, or form, in any way, shape, or form. I find that her testimony as to what happened today was fuzzy at best, and that at every point in time, an opportunity possible, she tried to talk about events from a different date. And I'm not denying that those different dates of incidences did or did not occur, but that is not the issue that is before the court. What's before the court is what happened on that particular date. The court found Mr. Smith, whether he has a habit of smoking marijuana, has a habit of getting into fights with other people, or even has a temper issue, which he apparently has a small one, as it showed based on his testimony here today. But his testimony was credible about what happened on that particular day. I found him to be truthful about the fact that he was in the bedroom, came out, she was drinking on that date, and they got into a dispute about the living situation. What words were exchanged as a part of that living situation, this court is unclear. However, I do believe at some point in time, he decided that he was going to try to remove himself from that situation. He went into the kitchen and made a telephone call to the police and was talking to them when he was hit, whether it was with her hand or with what it felt like a bottle to him. I disagree with Mr. Banas that someone of that size who may be surprised by the fact that they're being hit in the back at the time may feel like there's a bottle that's hitting them, whether it's their actual hand or an object. The bottom line is she did hit him without his permission, and that the prosecution has met their burden of proof with respect to this particular case. I find her guilty. Yes. So sentencing in this matter will be on. It's June 7th, the upper Monday. August 30th, 2021 at 10 a.m. We need to address bond.
Your Honor, I'm asking that you continue bond. I do have a copy of the bond violation report. I understand there are missed tests and you know, there, it's not improper for a court to think, well, if there's a missed test, maybe it was positive. I'll just point out that on June 8th, she tested negative. She did explain to me she missed some tests because she didn't have the finances to pay. You still have to test, or at least make every effort to make sure community corrections understands what's going on. She then did test on July 15th and was negative, and on the next day, her color or her number came up again, and I understand she did communicate with community corrections and explain what was going on. So I would ask that you continue bond, or that you allow her to remain out of custody on a personal bond, and of course, if you order her to test immediately, I'm sure she will.
Ms. Wellenbring?
Your Honor, at the bond, I do have concerns about substance abuse concerns about Ms. Blaisdell. And while I do know that testing is a monetary cost, and I would ask that Ms. Blaisdell be required to test within the next 24 hours and be required to test regularly, given that she has not been doing so. I would also like to ask for continued no contact with Mr. Cornelius Smith or Ms. Tiffany Moore. I don't think that will be a problem, given that they no longer live in the same residence.
This court is concerned about the bond in this situation. This is the second violation that I have received from Ms. Blaisdell. The first one was from the very beginning. We got a violation report on May 26th of 2021, at which time Ms. Blaisdell had been ordered to report to community corrections and test within 24 hours and to test regularly. She did not test at that point in time and did not even report for intake. Messages were left at the number that she had given on 2 separate occasions, and she still did not respond. It wasn't until she appeared before this court on June 7th that I issued a bench warrant for her for violating her bond. And so that happened on May 27th, and we didn't hear from her till she appeared on June 7th. At that point in time, I had a very stern conversation with Ms. Blaisdell and explained to her that I wanted her to test on a regular basis. And at that time, I also told her that I wanted her to test within 24 hours. That she did do. She tested on the 8th because she was here on the 7th, but then she did not show up again. And I'm not sure what happened, but apparently there were no tests between June 8th and June 28th. And maybe that's because I only ordered twice a month, and that was her second test, and she didn't show up. I gave her due consideration for her actual financial issues at that time by making it 2 times per month. Yet she did not show up. They gave her another opportunity on the 29th. She did not show up. They gave her another opportunity on the 1st. She did not show up. And then on the 15th, she decided she would come in. At that point, she tested negative, but then on the 16th, she didn't show up. So it appears to me that she has no regard for this court's orders.
Ms. Washington, may I speak?
Yes, ma'am, if your attorney approves.
If you want to address the missed test.
Talk to her?
No, Your Honor, I did speak with her about it. She explained to me it was a financial issue, and that's not an excuse, but if she's going to comment on that, then I think it's always helpful for court to hear, or usually helpful to directly from a client. So Ms. Blaisdell, if you want to address that issue, I have no problem with that.
Thank you, thank you. The thing, I've received disability and I'm paid once a month, which is on the 3rd. These dates they were coming in, all month of June, all my money was gone because I was living in hotel rooms because I was on a no contact order with Mr. Smith and Mrs. Moore. The money was all gone. There's nothing I could do. Month of July, the same problem occurred. I came in my home, but I had to buy a new TV. Everything's been stolen. I had to replace the locks on the doors. Money went, and I advised Mrs. Kirk, the Community Corrections, that I was going to address this with the court on Tuesday to let them know. But when Ms. Kerr did hit me up on, I believe, the 14th of July, she said, get in here tomorrow or I'm going to issue a bench warrant. So I did. And I borrowed money and I got in there and took care of it. Again, I don't do drugs. That's not an issue. No substance issues like that. But again, I won't see any money until the 3rd. I have $18 in my account until that date.
What type of tests are you doing over there, ma'am?
Under the tongue test, everything. Alcohol, drugs. It's the swab that I requested before.
Actually, I don't think they're doing an ETG. I don't see an ETG done in here. Ms. Blaisdell, please explain to me why you're saying you don't have money to do your ETG test.
There was no ETG test. It's all under the tongue, the swab.
All right, so why don't you have money to do the test?
For my SSD when I had money, and I borrowed money the last time for the 15th. It's not a large amount of disability that I receive.
How much are you receiving now?
$1,900 a month. I was spending $350 up to $400 a week in hotel rooms because they were still residing in my home and I couldn't go there. I struggle. And the rent here is $1,200 in addition to utilities. And now I'm also paying my own insurance and everything because that's part of a new state law, I believe, with disability.
Ma'am, I just heard you tell me that you put a TV ahead of your
That was prior to the test.
freedom.
When I first came back in my house on July 1st.
I'm sorry, what now?
July 1st, when I came in, on the 3rd, I went and got a TV. I had no choice.
What do you mean you had no choice?
I didn't have anything here. I'm pretty much a shut-in. I'm agoraphobic. I don't leave the house. So I have to have something. That's one of my issues. It's a medical condition.
All right, ma'am. This is what I'm ordering. You are to appear to have an ETG test within 24 hours. You can figure that out. If you don't have that ETG test within 24 hours, I'm going to issue a bench warrant for your arrest.
Oh, sorry. Okay. And I don't, what is the ETG? Is that a urine test?
I'm not sure what they do. They will decide that when they get there.
Okay, because I can't urinate in front of people. That's why I asked for the swabs initially. It's a little more expensive, but that's why.
Yeah, but that's not an ETG. I need to have an ETG test done so that I can figure out whether or not you're drinking alcohol.
Okay, fair enough.
And I'm continuing ETGs 2 times per month.
Okay.
If you're not there within 24 hours, we just had this conversation on June 7th, ma'am. This is my last time giving you an opportunity to not issue a warrant for you, okay?
Okay, understood. Do we know the cost of the ETG?
I don't.
Okay, me neither. I need to borrow money, so I just,
Then you can call over there. Your attorney can help you with that.
okay.
All right, they'll answer tomorrow because they're closed for today, so.
Okay, great, yeah.
That's what I was going to say also, Ms. Blaisdell. I'll reach out to Community Corrections. You can do that too if you have their number. Well, you must have their number because you've tested there. I believe the ETG is typically a urine test. They can also, I don't know if Community Corrections can, there's other ways that I think, but in any event, I'll reach out and try to figure that out for you.
Okay, I appreciate that.
All right. August 30th, 2021 at 10 a.m. for sentencing.
Your Honor, is there a pre-sentencing interview of any sort?
Thank you for reminding me. I didn't say that out loud. Yes, she does have to have the pre-sentence investigation report done. She's having financial difficulties, or I would send her for an alcohol assessment, but they do cost money, $100 and some odd is usually what they cost. So instead, I'm gonna have my department ask her some questions regarding her usage of alcohol, and we'll go from there to see if we can get something in place for her. Okay,
Yes, thank you. I appreciate that. That will save her a little bit of money. Okay, Ms. Blaisdell, I will follow up with you and make sure, see if you have any questions about going forward.
Okay, definitely. I appreciate it.
all right, we're all set. Thank you.
Thank you.
Thank you, Renner.
Thank you, Your Honor.
Thank you.